Facilities Commission. And with me this afternoon are Commissioners Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, Tommy Tucker, and Stephen J. Levitas. I now call for oral argument hearing and docket numbers E-100 sub 206 in the matter of offshore wind development. Before we proceed further, and as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. Before the Commission is Avangrid Power LLC's petition for a declaratory ruling pursuant to North Carolina Declaratory Judgment Act, which is North Carolina General Statute, North Carolina General Statute Section 1-253. And going forward, I will refer to Avangrid Power LLC as Avangrid, and I will refer to Avangrid's petition for declaratory ruling as the petition. The petition seeks an order from the Commission finding that, number one, a non-utility third party may share ownership of an offshore wind energy area, or WEA or WEA, and facility selected by the Commission for purposes of compliance with the state's carbon plan statute, which is North Carolina General Statute Section 62-110.9. And number two, that a WEA leaseholder is not required to submit a build, own, transfer, which I'll refer to as a BOT deal structure, to Duke Energy Progress LLCs and Duke Energy Carolinas LLC, and I will together refer to Duke Energy Progress and Duke Energy Carolinas as Duke. So Duke's Offshore Wind Acquisition Request for Proposal, or ARFI, or any subsequent request for procurement in order to meet the terms of the ARFI. On March 4, 2025, the Commission issued an order scheduling oral arguments and requesting comments on Avangrid's petition to occur today, April 14, 2025 at 1:00 p.m. at this location. On March 17, 2025, the North Carolina Sustainable Energy Association, or NCSEA, Total Energies Carolina Long Bay LLC, or Total Energies, and Duke filed initial comments responding to the petition. On March 24, 2025, Avangrid filed reply comments. Also on March 24, 2025, Total Energies filed a motion for leave to file limited reply comments, which I will refer to as the motion. On March 31, 2025, Duke filed a response in opposition to the motion. On April 10, 2025, the Commission issued an order that accepted Total Energies' limited reply comments and that also provided additional procedures for the oral arguments. As a reminder to the parties, the Commission's April 10, 2025 order directed the parties to present their oral arguments in the following order. First, Avangrid, then NCSEA, then Total Energies, and then Duke. The parties were further directed to limit their prepared remarks to 15 minutes each, although Duke will be allowed an extra 2 minutes for a total of 17 minutes in order to respond to Total Energies' limited reply comments. Avangrid will be afforded 2 minutes to make a brief rebuttal. And that brings us to today. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good afternoon. My name is Ben Smith from the law firm of Kilpatrick, Townsend, and Stockton, and I represent Avangrid Power.
Good afternoon, Mr. Smith.
Good afternoon. My name is Justin Smolowski on behalf of the North Carolina Sustainable Energy Association.
Good afternoon.
Good afternoon, members of the Commission. My name is Mariana McMurray, and I'm with the law firm of Ward & Smith. I'm appearing today on behalf of SIGFR 2, SIGFR 3, and CUCA.
Good afternoon.
Good afternoon, Commissioners. Robert Josie with the law firm Nelson Mullins on behalf of Total Energies Carolina Long Bay.
Yeah, Weston Adams with Nelson Mullins on behalf of Total Energies Carolina Long Bay as well.
Good afternoon.
And good afternoon, Chair Cameron, Commissioners. Jack Chirac on behalf of Duke Energy Progress, Duke Energy Carolinas, and I'm joined this afternoon by my co-counsel Kathleen Richard, along with Brett Bryce-Work with law firm Wirewood.
Good afternoon. And before we begin with the oral arguments, are there any preliminary matters that we need to address? And so we'll begin with the oral arguments. We will be keeping track of the time, and we're timing it. We will be holding the parties to their 15 minutes and 17 minutes for Duke. And then after the presentations are made by the attorneys, the commission will have questions about the different parties' positions and arguments. So, Mr. Smith, if you're ready to begin.
I'm going to move to the podium if that's all right.
Yes, please.
Good afternoon, and may it please the commission. My name is Ben Smith, as I said, from the law firm of Kilpatrick, Townsend, and Stockton on behalf of Avangrid Power, the petitioner in this action. The crux of the petition is whether Duke Energy is required to be the sole owner of offshore wind generation assets or facilities as part of a commission-approved carbon plan. The background here, to level set a bit, is that there are now currently 4 wind energy areas off the coast of North Carolina. There's Kitty Hawk North, now Dominion's Seaval South. There's Kitty Hawk South, owned by Avangrid Power. There are the 2 Carolina Long Bay wind energy areas owned by Total Energies and Duke subsidiary Synergy, respectively. And these 4 different wind energy areas have been looking for different paths to market. Particularly Kitty Hawk South and the 2 Carolina Long Bay participants would like to go into Duke Energy and provide energy from wind energy areas for Duke Energy's ratepayers. This has been a consistent issue in front of the commission since the 2022 carbon plan, the initial carbon plan proceeding. The initial carbon plan proceeding, as you can recall, had 2 issues that are relevant to today's discussion. The first issue was that we had an offshore wind study that was ordered by the commission at the time. The idea there was to get an idea of what the cost would be associated with offshore wind development in the state at the time. That offshore wind study was eventually filed with Duke's second carbon plan. I'm going to call that the CPIRP carbon plans. And during that CPIRP carbon plan, that filing was made in conjunction with their initial filing, which had a preferred portfolio that did not actually include offshore wind. However, in January of 2024, Duke revised their demand forecast, meaning they expected a higher demand in the future, and that triggered offshore wind to be part of their preferred portfolio. Consequence there was that the preferred portfolio from Duke was settled with the public staff and with several other interveners, and it included in aggregate 2,200 to 2,400 megawatts of offshore wind to be developed off of North Carolina to provide electricity and capacity for North Carolina ratepayers by 2035. The other thing, and I'm going back to the 2022 order that came out of that, was the discussion on ownership. Now, as you might recall from some of the comments, this was discussed by the interveners in their comments, and I wanted to quickly make a clarification as to what the difference is between this proceeding and what happened in 2022. In 2022, the discussion was about whether a PPA-style third-party owned facility could sell into Duke. That's not what's at issue today. At issue today is whether or not they can jointly be owned between Duke and a third party. In our case, the wind energy developer, Avangrid, or some subsidiary thereof. What we're looking for is just different than what we looked at for 2022. And in 2022, the commission actually sort of tacitly acknowledged the fact that they didn't define their ownership and what that meant. They said they agreed with Duke, and they said, yes, Duke does have to own anything that's a generation facility in a commission-approved carbon plant. But what they didn't do is they didn't define ownership, and they used footnote 9 in their initial order to say, ownership is not defined here. And that's sort of one of the seeds that we're working off of here, understanding that there is a clear issue and controversy. And part of the issue here is that 62110.9 does not define ownership. It's ambiguous, and it's difficult to decide whether it means this is a black and white Duke has to be 100% owner or can jointly own something. So I want to talk a little bit about the actual controversy. 1-253 allows the commission to determine the rights, legal status, legal relations where there's uncertainty in statute. And 62110.9, like I said, requires the Duke to own everything aside from the utility scale solar carve out, but does not define that ownership. The commission, like I said, acknowledged and declined to define ownership in the 2022 carbon plan order, but a commission order now to clarify the issues can lead to a pathway that would alleviate costs and expenses that ultimately will de-risk ratepayers. Now, Duke is likely going to say that we've provided an alternative submission pathway in the RP process. I want to discuss the RP process for a second. The RP process was a production that came out of the 2024 carbon plan order, and it was part of the negotiated settlement between Duke and public staff and some other interveners, and it includes a pretty arduous list of things that you have to include. You have to include project description, decommissioning, project site conditions, payment arrangement, development and logistics plans, the technology issues, the balance of equipment type and technologies, a port and vessel plan, energy production estimate, hurricane risk, permitting plan, environmental protection plan, some of the interconnection issues and interconnection plan, a stakeholder engagement plan, and a project schedule, amongst many other things. An RP bid proposal is no small task, and it's due in 17 days. So the issue is clear and is before us today, whether or not my client can move forward with a proposal that includes joint ownership. Now, again, back to the alternative submission pathway that Duke has proposed. The issue there is that Duke, on page 4 of their comments, reveals where they really lie, is that they do not believe that joint ownership is lawful under North Carolina law. Now, that flies in the face of some of the things that they've done in the past with other generation types. But what I want to talk about here is we have 17 days to come up with what will effectively be an illusory, bid proposal process or bid proposal that will include what they call a minimum qualifying submission with a BOT type deal, which my client, frankly, isn't all that interested in. And what we would prefer to do is a joint venture would keep us with the project through the life of the project. And that's the most important thing here, is that we think by de-risking the project, by spreading it out through a joint venture where the developer remains with Duke Energy as a partner, will be the best outcome for the ratepayers and will allow us to give the most competitive bid process possible, in the RP bid process, and then in the subsequent RFP. Now, as you all know, the RP bid process includes a blind ceiling price. There's significant pressure to keep the costs as low as possible. So while I will not say that de-risking is some magic bullet that will make this project the most inexpensive project ever, it's certainly going to be helpful. And de-risking by sharing the risk between the ratepayer and a third party is something that we've seen as good public policy. Talking about public policy, another example that you can look to is up north in Virginia. The CVOW project is an example of an equity split between Stone Peak and equity sort of supplier for the project and the CVOW project with Dominion Energy. The issue there that they were trying to solve was exactly what we're talking about here, ratepayer risk and de-risking the project. Now, there are some certain distinctions between what's going on in Virginia and North Carolina, but there's no distinction in the fact that the plan here is to do this in a way that will make the project more attractive and acceptable and probably be able to beat that ceiling price that we're worried about. Now, I also want to make very clear, and I said this a little bit, but I want to say again, Avangrid is not interested in third-party sole ownership, not interested in becoming a public utility in North Carolina, not interested in encroaching on any of the regulated utilities, the regulatory compact, or anything like that under Chapter 62. Our interest is not to subdivide the project unless that's what is the best outcome. But what we're looking for here is to come up with a deal to sell as much electricity into Duke Energy's with a partnership with Duke into their rate base as possible in a way that will be most competitive. One other thing to consider is that Duke's president, Kendall Bowman, testified to this very idea. In the CPRP live hearing, she testified that joint ownership and she was, I believe, referencing the CCs, the combined cycles in Roxborough, but the point remains the same. By splitting that risk with, in that case, NCEMC, it helped to make it a more affordable way to move forward. Offshore wind lends itself to a joint venture at the start. Avangrid doesn't have experience doing BOT. It does have experience doing JVs and joint ventures. And I think that that's going to be what you see across most of offshore wind. BOT is not something that people have done before. We've often talked about not being first movers on something. This would be a first mover type of interaction, I believe. Offshore wind is CapEx intensive. If we want to, again, talk about how expensive things are and how much cash on hand is going to be necessary, splitting that between more than one party is going to make it more acceptable. The same thing we talk about with Stone Peak in Virginia. That's the type of thing we're looking at to try and de-risk the ratepayers and make this more affordable going forward. Duke is in a build phase with considerable headwinds. We have decarbonization, we have demand growth, and we have aging infrastructure that has to be updated. If you consider anything to de-risk ratepayers would be a good idea to move forward and to sort of conquer the obstacles that we're going to see in this state going forward. As I mentioned, the alternative submission, it's not workable. Duke offered it as a minimum, as additional to the minimum qualifying bid. But as I said, they've already stated that it's not lawful under Chapter 62. So to me, that's not, there's no cold comfort there. And this, again, they offer this saying that you can't own it under state law while they also co-own facilities with NCEMC. And they're likely going to parse my words here to say, well, that's a split offtake agreement. And they're not wrong. It is a little different. A split offtake agreement with NCEMC would be slightly different than what we're looking at because we're not looking to split offtake from Avangrid between two other parties. What we are talking about, though, is a de-risking mechanism, which, again, Duke President Bowman acknowledged in live testimony, and which is reflecting the fact that Duke still has, and I haven't seen all their contracts, but from the filings in the CPCM proceeding, they still have dispatch rights for those Roxborough facilities. So we're still talking about the control and the type of thing you would think about. It's not just a clear split offtake situation. The RFP bid process, which Duke opposed seeking, or I'm sorry, which Avangrid actually opposed seeking a more efficient RFP process, is arduous, time sensitive, and costly. I already read the list of things that are included, and that's not even all of them. Requiring effectively two totally different types of bids, with each bid effectively being illusory, is a waste and an expensive issue for the developers. North Carolina law has not defined ownership in utility and generation. And I want to make that very clear that this isn't something that's been accepted or defined anywhere. What I used was tax law to sort of look at how North Carolina law has defined ownership of things. Talking about how tax policy allows for joint ownership when scrutinized tax liabilities and things like that. I thought it was illustrative for what we could be doing here because it isn't defined. And what we have here is under 62.110.9, the requirement for ownership without that definition that we need. The tax law basis shows a sort of factors test, where you don't have to worry about, there's no, oh, you have to own 50% or 50% or 51.49 or something like that in order to get the benefit, but really a list of factors to see who is the owner, who has control, and a series of other things to allow for who is the true owner, who gets the benefits of tax exemptions, or who gets hit with tax liabilities and things like that. It's not a clear issue. It's not a black and white issue. And that's why commission direction is very, very important. On timing, the one other thing I wanted to say on this is that we've requested, and I know I've mentioned that we only have 17 days to respond to this RFP. We're working diligently towards it. But having direction here will make this process much more straightforward and much easier. Kicking the can further down the road on this decision would not do us any good and would cost us lots of time, billable hours on my behalf, and a lot of manpower for my client. And while, jokes aside on the billable hours, we need to move forward efficiently in the benefit of North Carolina ratepayers. Any cost and any penny added to these costs of these projects and the underlying value of them is going to ultimately fall through the regulated processes in North Carolina ratepayers when the projects move forward. And I don't think that it's anything incorrect to say that this is a problem that is here and now and must be fixed. I see that I still have 2 more minutes, but I'm going to ask that the remaining 2 minutes be used for either question answering or for my rebuttal.
So, Mr. Smith, you can reserve your extra 2 minutes as part of your rebuttal. So you would be permitted 4 minutes for rebuttal.
Please.
And we'll proceed with commission questions then. Okay. And thank you for your argument and your presentation. And I have a number of questions. I think that this is a very complex legal question that's before us. And we commissioners want to make sure that we have a full and complete understanding of the issue and the law that is present that we're going to be relying upon. But what I want to start with is, actually, I'm going to refer first to your comment about testimony in the CPIRP. expert witness hearing, and you referred to, and this I believe was in your initial comments or your petition for declaratory ruling, you talked about North Carolina, Duke North Carolina President's testimony in which Kendall Bowman cited the Roxborough facilities and stated that Duke would explore joint ownership of generation assets to reduce customer ratepayer risk and improve the financial backing of Duke. And I located that testimony in transcript volume 21 at pages 662 through 663. And I want to make sure that the record is clear. My reading of that testimony is that Ms. Bowman was talking specifically about natural gas fired facilities and not offshore wind. But do you agree with that, or do you have a different understanding of what her testimony was during the evidentiary hearing?
No, I believe you're correct. She was speaking to natural gas and not offshore wind in that context.
Okay. And the next line of questioning that I'd like to talk to you about is the stakeholder process after the commission issued the CPIRP order in November of 2024. And what I want to make sure is that I have an understanding of what happened during the stakeholder process. And your declaratory ruling, your petition, seems to imply that Duke might not have complied with the directive from the commission about the stakeholder process. Although in reading through the petition for declaratory ruling, there was no, a complaint was not filed. There was no direct request of the commission to do anything about that position. And so I want to understand, and I'm going to be asking Duke the same questions about whether Duke did in fact comply with the directions in the CPIRP order.
Yeah, as I recall from the CPIRP order, there was a requirement that Duke work on the structure, deal structure and timeline and the different project details with the developers. I think that within the broad read of that, I think that they did comply. But where we sort of differed is that the requirement for this minimum qualifying submission. And then what we've seen in their comments where they said, well, we actually don't think that joint ownership is lawful under North Carolina law. And so there was a disconnect on our side from Duke as to what we could move forward with. And that's sort of the crux of what we're looking forward here. I don't necessarily want to point a finger at anyone and say they didn't comply with an order, but I do want to get to the bottom of whether or not joint ownership is lawful.
Okay. And then just to be clear for the record here, I looked back through the ARFI, and it says that Duke conducted the first stakeholder meeting on December 19th of 2024, the second stakeholder meeting on January 9th of 2025, and then the IE held one-on-one meetings with the WEA leaseholders between those two meetings. Are you in agreement that that happened?
Yes, to my recollection, it did.
Okay. And during those meetings, does Avangrid, did Duke talk about the structure? The structure of the BOT structure, and then was there also discussion about the alternative submission during the first and second stakeholder meetings, and then also the one-on-one meetings that occurred?
The first stakeholder meeting was, there was not a lot of back and forth. That was more presentation style. Second stakeholder meeting had some back and forth, but I would call it more of a question and answer type of, rather than any sort of negotiation or discussion. We did have some pushback on some of the language involved with the alternative submission. Avangrid never actually agreed that the alternative submission, but I think our language is something to the effect of we're not going to object in order to move forward briskly. But then when we saw the totality of the ARPI procurement paper and all that was involved, we read it to say that there was no joint ownership contemplated or allowable under it. And again, that was amplified again in Duke's comments where they said they didn't think it was lawful under Chapter 62. And so I think that from my point of view, Avangrid had gone forward with the expectation that they would be able to move forward with the joint venture after the initial CPIRP order. And as the ARPI process moved along, and then when we got the actual ARPI, that did not seem to be the case anymore.
But for purposes of this proceeding, you are not contesting the stakeholder process, or there's nothing before the commission that you're alleging or asking the commission to make a decision that Duke in any way violated the CPIRP order. Is that, I'm just kind of making sure that we're on the same page about this.
Yeah, I don't think so. No.
Okay. And then I think that we all recognize that we're under some real time constraints here because the bids are going to be due in just a couple of weeks. We have the oral arguments today when the commission needs to issue an order. And what we'd like to have a better understanding about is the ARFI was issued on January 29th of 2025. And can you help us to understand the time period that Avangrid learned or discovered that it was going to be dissatisfied or object to the terms of the ARFI, and talk to us about when that happened and then why there wasn't more immediate action so that all of the parties would have some more time, because this is the time frame is pretty quick, and we have a lot of work to do to try to meet what Avangrid is asking for in regard to an order.
I agree. And as you all likely recall, I think I was one of the people pushing for us to move as briskly as possible towards an offshore wind conclusion during the CPRE proceedings. So I can certainly agree with all of that. I think that from our perspective, we wanted to take some time to understand what would be involved with building out the very lengthy RFP bid proposal response and understand what was available and sort of whether Avangrid had the background or understanding to go forward with the BOT or not. And what we kept coming back to is that this is not something that's done in offshore wind, not something they've done before. It's not something that's been done in North America. And I'm not aware of it being done anywhere in the world. And so to the extent that they wanted to move forward, they wanted to be very calculated in how they asked asked the commission and understand that there was no other alternative pathway for us to move forward other than this petition. So yeah, it probably took a few more days, weeks than maybe it could have at the expediency that we probably needed, but we went as quickly as possible while evaluating a very complex system of issues and also discussing with other stakeholders their positions so that we wouldn't be too askew from what was best for the offshore wind community generally.
Okay. And my understanding of the dates that we've got coming before us is that the deadline for submitting bids for the ARFI is April the 29th. Is that correct?
Yes, it's the end of April, yes.
End of April. And my recollection is that Avangrid has asked the commission to issue an order no later than April 28th, the day before the bids are due for the ARFI. Is that correct?
That sounds correct, yes. And I think we asked for a 30-day extension from the date of whatever day you issue the order.
Okay, so that was going to be my question. If the commission was able to issue an order by April the 28th, is Avangrid, and then also I'll ask the same question for Total Energies, will the two companies be in a position to submit bids the next day? Is that possible? Or do you still need additional time to prepare and submit the bids?
We are moving forward with preparing our bid. And we are anticipating that there would be no extension granted because that is what we would envision as the worst case scenario. And that's the possibility that we're trying to prepare for. We, of course, would like more time to respond to whatever the commission's order. But in terms of a BOT sort of minimum qualifying submission along with an alternative submission, we are moving forward and intend to comply with the commission's deadlines as necessary.
So what would be Avangrid's specific request of the commission be if we are able to issue an order on April the 28th? Will Avangrid, are you asking us to provide an extension of an additional 30 days, or will it be sufficient if an order is issued by April the 28th, or do you still need the additional 30 days?
We would request the additional 30 days because whatever the order says could be depending on how joint ownership is defined or not, could vastly impact what particularly the financial issues in the RP include. And I think that the language that you all used was as binding as possible. We want to be as binding as possible, as close to a true bid as possible in this process. And so we would still request the 30 days, understanding that if we don't get it, we're going to give it our best shot.
Okay. And this may be more of a question for Duke, but in case you're able to answer it, if the commission were to provide some sort of an extension, either to issue our order or after issuance of our order, what does that do to the schedule for the ARFI and how it relates to Duke preparing its next carbon plan application? Is the time too tight? Are we creating problems for modeling purposes and preparation of an application? If you're able to answer that, I'd like to hear your perspective, but I'll certainly be asking Duke about that as well.
My perspective is yes, it's going to create issues because of the timing issue. And we've seen this a number of times. We saw this last year when they had to update the demand forecast and had to resubmit the models and go through that again. And no one likes having to push the deadlines back. And we certainly would push forward as quickly as possible to move in a way that would allow Duke to move forward with their modeling, because ultimately we need to move forward as quickly as possible to meet that deadline too, so that the projects could move forward if they beat that blind reference price and go into the RFP, right? So we're similarly pushed to meet that deadline, and we'll move forward as quickly as possible. I can't speak to Duke's modeling and the timing they'll need, but I can speak to the fact that I think that you'll see a considerable amount of stakeholder engagement and support for something that would provide a competitive option to meet the decarbonization and generation requirements for the state.
And Mr. Smith, I'm going to shift gears here and talk about a BOT structure. And I believe in your reply comments and also in your petition, and then in your oral argument today, I believe your testimony, the information is that a BOT proposal or structure for offshore wind is unprecedented in the United States. Is that correct? Are there any examples in the United States of an offshore wind project that had a build, own, transfer structure?
Not that I'm aware of.
Okay. And for clarification as well, one of the key issue here is about the legal definition of ownership in North Carolina, and specifically in House Bill 951. And I just want to, I believe your testimony was you relied upon, and I think Total Energies did as well, upon law in the tax area of law. Is there any law in North Carolina or any case that defines ownership as being less than 100%? Is there any basis or authority that we can rely upon that will provide that information?
The best case that I found was the tax case, the Blue Ridge Housing and Baskerville case that I cited in my comments.
Mhm.
And I know Mr. Josie and his team, they had some really interesting arguments related to the Duke, South Carolina, and some of the nuclear issues there, where there's a joint ownership structure that was in place. And I'll leave that to them to speak to. But aside from that, it's I think a relatively untapped issue, particularly when it comes to a regulated utility. I do think that it's an important thing to discuss, because prior to 951, it probably wasn't ever considered too much of a litigated issue, but because of the issue here, and I'll even reference Duke's comments in the original carbon plan. They reference ownership as a substantial ownership in their comments. They don't ever say 100% ownership in their comments either. I would probably argue that might have had to do something with the contemplation of the Roxborough combined cycle split ownership. But what you're not seeing here is any sort of definition in state law, statute, case law, or even commission precedent that shows, hey, this is the split of ownership and this is how it has to be under state law.
When you refer to substantial ownership, and Duke referenced substantial ownership, was that in the 2022 carbon plan proceeding or in the 2024 CPIRP, or
That
both?
was in the 2022 carbon plan proceeding on Duke's comments when they were briefing on the issue of ownership as to third-party ownership and PPAs. I think the sentence was something to the effect of, it's important for North Carolina under a cost of service recovery to be able to have substantial ownership in its generation facilities.
And moving on, what the commission is trying to understand is, what exactly does Avangrid want the commission to issue a decision on? What what proposal, because it's really not clear, and this goes to the question of actual controversy or ripeness of the issue, because we don't have a proposal that has been submitted to Duke that we could, for example, if it was a equity sharing proposal that I think is from listening to your argument, I think that that's what Avangrid is looking for. But there's also the possibility of split ownership, as you talked about, which would be similar to the Roxborough natural gas CPCN proceeding, in which the North Carolina EMCs would own a little more than 16% interest. So we don't have an actual proposal that we can look at and determine how it fits with the definition of ownership. Can you tell us more about what specifically Avangrid is planning to submit for its alternative submission? And I'm going to be a little long-winded here, but you said before that equity ownership is what is the model that Avangrid is most interested in. And in your reply comments, I noticed that you said that the third-party offtake arrangement, like the Person CC natural gas facility, is not something that Avangrid was going to be pursuing. But then I thought I heard you mention during your argument that that would not be your the preference, but you weren't ruling it out. Can you help the commission understand what the options for that alternative submission would be?
Sure. If we're required to go through the alternative submission portal, what we would have after completing the minimum qualifying submission would be a submission that is a joint venture where there would be an equity split ownership with the Duke Energy as regulated, receiving the funds through the regulated processes to pay for the project in the way they see fit and the commission sees fit. And with those funds being split between, based upon the sort of shares between the two entities. All the details of this are not necessarily nailed down yet as we sort of continue to develop. That's something going on right now. But I think from a 30,000-foot view, that's what it looks like. On top of that, there would be considerations for design, construction, operations of the project that would all be built into the contracts and the things. The ARFI, as I mentioned, is a considerably longer sort of term sheet type of process than what I've seen typically. And what we're looking at here is to try and figure out as much as we can. And that's why this process has been very important to us. What we're looking for is an order saying joint ownership is okay, because then we can move forward developing this proposal. To the extent that we're saying that ripeness isn't there yet, we're trying to do this in advance. The way I've seen, and I've got a quote from a Perry versus Bank of America case from a judge who said, declaratory judgment relief permits one who's walking in the dark to ascertain where he is and where he's going, to turn on the light before he steps rather than after he stepped in a hole. That's what we're seeking here. We don't want to go forward and then have an alternative submission, which is going to be the most cost competitive submission, be rejected because Duke says it's not lawful under Chapter 62. And then we'll have to litigate this proceeding down the line after the next CPIRP proceeding's already begun and modeling has gone through. We think right now it's right and it's time to move forward.
And if the commission were to determine that there is an actual controversy, you've said that the decision that you wanted from the commission is that joint ownership is permitted under House Bill 951. Do you need more than that, though? Because let's say that Avangrid submitted a proposal for sharing of equity ownership in the facility. And do we need to provide a level of certainty about the different types of potential co-ownership scenarios? For example, third-party offtake, like the Person County natural gas plant, is one, and then the equity, the split of equity ownership. If we don't make a decision about that, are we potentially going to have another declaratory ruling proceeding before us, or complaint proceeding, or further litigation? What do you need from us, don't we need to have more specificity, or is that not necessary?
I don't think it's necessary because I think at that point, then cost will be the issue that we have to take on. Because once we know that joint ownership is lawful under Chapter 62, then we can proceed coming up with a deal structure, a structure of the ultimate facility sort of deal that will allow the best and most cost competitive option. Because that's really what the strain is going to be for offshore wind. We're not, we're going to have to be like I said before, saving every nickel and dime to be able to make it under that blind reference price, because we don't know what that's going to look like. And so we need to do everything we can to move forward and make this as cost competitive as possible. And if that means some, you know, optimized sort of model where there's a shared split equity, you know, 70-30, 50-50, whatever it looks like, while still following North Carolina law, still following and allowing Duke's regulatory compact to persist, that's what we've looked for.
And related to that, since we don't have the proposal from Avangrid or Total Energies, and the alternative submission, let's just say hypothetically, is that share of equity. Without having the details in front of us, are we not potentially putting the commission in a position to be having to make further decisions? How are the parties going to determine what that equity split would be? What would be fair? Those are details that are not before the commission that could be contested among the parties.
Sure.
And how do we make a decision now without having the level of detail?
I think that those are negotiated terms between the parties that in my eyes will come down to what will be the most beneficial for the ratepayers. And that will help allow us as we move forward into another rate case phase to sort of say that this won't cause as much cash on hand to be required for the utility. I agree with you that there's no certainty here beyond the fact that we were looking for whether it's lawful to jointly own or not, and that there's potential for conflict, of course, but I also think that this will alleviate situations in other areas. Like I said, future rate cases, but also if at some point we submit an alternative submission, or Total does, that's the most competitive one, and we come out and Duke says, nope, we're not allowed to do that under Chapter 62, we're still going to have to litigate this issue, and it'll just be later. And in terms of the details and getting down to the nitty gritty, I think that's going to be submission by submission. But what we're going to look for is to work with Duke, because Avangrid doesn't look at this. We're trying to be as the least amount of litigious possible, believe it or not, because we want to make sure that we know this is a long-time joint venture that we're looking to work with and partner with them. So that's the goal here.
Okay. And then just a couple more questions. For the equity sharing proposal, explain to me how will it work from a practical standpoint for Duke to recover its costs on a cost of service basis? Because that is what's required by House Bill 951. How can that be assured?
Sure. I think that the way we conceive it on a very high level is similar to any sort of contractor, subcontractor, where you have a Duke Energy regulated recovering their ratepayer funds, and then they're funneling that into the costs associated with the facility and splitting those between us and them. Something to that effect is what we're looking at. Again, we're very high level because one, I don't have the RP bid proposal in front of me, and two, we're still developing it.
Okay. And I think this is my last question before I turn it over to the other commissioners about the build own transfer proposal that's currently required by the ARFI. Can you help me and the commissioners understand why it is so burdensome that Avangrid and Total should not have to provide, as requested by the ARFI, a BOT proposal? Why help us understand why this is a very large project, and why is this one proposal so burdensome that you should not have to do it?
Sure. And just to restate, Duke's position is that the build and transfer is the only lawful way going forward. And that's one thing we certainly are opposing here. We want a joint ownership agreement, but if required to go forward with the build and transfer, that puts a lot of risk during the front end of the project on the developer. That's the design and the construction of the project. And permitting and everything else, which would all go towards the developer before selling it later. As you can imagine, financing that will be difficult. And that's something that we've seen kind of go out of favor. I'm speaking a little bit out of turn, but I've sort of overheard other like solar developers talk about how build own transfer isn't something they're seeking as much in the state anymore. So it's something that I think that as we see prices go up, different constraints, both at the federal, national, international level, that affect these large projects, having a shared risk profile, I think is in the best interest of everyone.
And that reminds me of one of the concerns about the BOT proposal that you raised in the petition was about confidentiality. And I reviewed the ARFI on page 12. It says that the utilities will take reasonable precautions and use reasonable efforts to protect any proprietary or confidential information contained in the submission. Do you still remain concerned about the confidentiality, or is that really just kind of a side issue of providing the BOT proposal?
It is not our primary concern, but it is a concern. As you might recall from the initial 2022 IRP proceeding, the carbon plan proceeding, that was an issue, but particularly between my client and Duke Energy and the confidentiality involved there. And it ended up resulting in what I think was probably a worst case scenario, which was in the sense of we had an offshore wind study that had pricing in it that was redacted, which makes sense, but we didn't move forward with an RFP, and then that pricing got stale. And so now we're going through this process again. And I think the process is good and moving forward is good, but the confidentiality issue is still remains an issue. And if you can imagine, I mean, we have competitors here, and to the extent that we can keep them out, and we have potential offtake too, because for my client in particular, they could go through Virginia and they could have a different offtake agreement through PJM. And so when there are large industrials, large tech companies who are involved in these dockets and who have access, it of course raises our ears up to say, we have to be very, very calculated and concerned about releasing any sort of pricing details that are, even if they're subject to sort of NDAs and things like that, it gets people a little bit nervous. And so while I don't think that it is the primary concern, it's certainly something we care about.
Okay. And then one last question thank you for that. You talked about offtake selling into PJM. I just want to make sure I'm entirely clear about this. What Avangrid is not planning to propose is a co-ownership scenario in which it would own a portion of the facility and a portion of the power that is produced, and then sell at wholesale in North Carolina, or or send it to PJM and sell it to a wholesale customer in PJM. That is not what Avangrid is planning to propose. Is that my understanding?
That's correct. Current RP bid proposal does not contain any sort of split in that way or any sort of wholesale through PJM or elsewhere.
Okay. Mr. Smith, thank you for your explanations and answering all the questions. And I will now check with the other commissioners. Commissioner McKissick.
Just a couple of questions. As it presently stands, this build own transfer model is one that you feel would be challenging and difficult, and you've not seen it utilized anywhere else in the United States. Is that correct?
That's right.
Now, Duke would like to have that as a prerequisite that you comply with that before you submit an alternative submission. Is that correct as well?
That's correct.
Is Avangrid prepared to do that? I thought I heard in your comments earlier that they were prepared to do so, even though that seemed to conflict with what I had read prior to that time.
Correct. We are preparing to move forward to be able to submit something that would comply with the commission's order and with the RP requirements. What I'll tell you is that I would imagine that the alternative submission will be a more competitive submission than a BOT. I don't know that for certain yet, but I can tell you that we believe that that's the best pathway and avenue for us to provide the most competitive bid. And again, we're always thinking about that ceiling price that we don't know.
So in your original petition, you, in terms of the relief requested from the commission, it was to not require that Avangrid have to submit a build own transfer model, and that you only had to move forward with an alternative submission. But as it stands today, your thoughts have changed. Is that right? Or would you prefer the commission still comply with the original request that was made in your petition?
My thoughts haven't changed. I think the way I would look at it is that we think that the alternative submission would be our prime submission in any event. And if we're required to have a BOT submission as well, that would have to move forward if necessary. But it's going to be expensive and time inducing, and we don't think it's going to be difficult to adhere to as binding as possible sort of thoughts that the commission had asked us to consider when going through this RP process.
So it sounds like right now the key issue you want us to focus upon really is the ownership issue, the co-ownership issue, and that Avangrid would be content with the commission deciding that co-ownership was permissible without getting into specificity relating to whether that would be an equity type of ownership or split ownership or in terms of those types of details. Is that right?
That's right. We're just looking to get some specificity as to 62-110.9 regarding the ownership of the generation facility and whether we can have a submission that's lawful under North Carolina law where it's a joint venture with a joint ownership between Duke and the wind developer.
And as it stands today, you're not really able to specify what that joint ownership might look like.
Not beyond a sort of 30,000-foot view that I gave Chair Kemmerite.
Right.
But we are working on the details and we anticipate having a competitive offering.
Okay. And I think you referred to footnote 9 in the original carbon plan as not leaving this ownership undefined.
That's right.
So your relief you're seeking today is to provide some clarity in terms of what was envisioned.
That's right. That's right. Because this issue was sort of litigated around during the 2022 carbon plan. And the focus there, and a lot of that was because the retail folks thought that the best way to move forward, the industrial folks thought the best way to move forward was a PPA model to allow for, really de-risking the issue for the utility. What we're seeking is something slightly different, a joint ownership model that was not defined in that 2022 order.
And from what I also understand, if we were able to enter an order by April 28th, what you would also seek is additional time.
If possible, we would love an additional 30 days to make the best and most accurate and the most binding as possible RP bid proposal that we could.
And if we did not grant that additional time, do you feel you could still get in a credible, viable alternative submission that would?
We are working on a pathway to have a submission that would effectively be an alternative submission. If you all granted as joint, it would likely be our sole or main submission and would be prepared. What this would allow us to do is not have to have so much legalese out there saying, oh, subject to commission order, this would be the split, the split, things like that.
Thank you. I don't have any further questions.
Commissioner Hughes.
Yeah, Mr. Smith, I know you're not a pure accountant, but I'm going to go ahead and try.
Okay.
A regulatory accounting question. I'm just really curious, and if you know the answer for Virginia, how their Dominion's doing it, but with this idea that in a vertically integrated regulated utility, that part of their asset base is co-owned. Are you seeing that a commission, either in another state or in North Carolina, just treated that entire asset as owned by the regulated utility? Because we go to great efforts to figure out what the regulated utility's return on equity is. So I'm just curious what a rate case is going to look like. Is it, and again, I know you're not an accounting specialist, but I can ask Duke the same thing. Are you familiar with that occurring anywhere?
Yes. In terms of occurrence, I mean, Virginia is probably the best way to look at it. But theirs is really hammered down by statute and by commission order. I believe the original commission order sort of went through, there was a dissent or concurrence, I can't remember which one, but where one of the commissioners went through the series of concerns about how to bring this into the rate base. And then the Stone Peak sort of, they had a very, very specific way that Stone Peak was able to get a return that fell within, what was allowed under the regulatory compact in that state, and sort of not fall into an area where they were a public utility. They sort of made this third-party entity, this vehicle that fell under Dominion, but Stone Peak was a beneficiary from. And that's sort of what I see happening here to some extent. I think that we would not want to sort of push on any buttons that would affect Duke's ability to sort of recover funds, anything on their rate-making side. And honestly, we would take a backseat to how they would request recovery, because I know they have different things that they do, particularly for large CapEx projects. But what we would try to do is try to figure out the best way for us to get fall within the normal rate of return that we can expect for a project like this, and just sort of be a beneficiary under Duke's umbrella.
Okay, that helps. I don't have any other questions.
And I'm also happy to file a late exhibit. I know y'all don't always want those, but that explains how Stone Peak comes out, because I know that was released publicly.
Okay, well, I'll leave that to our presiding commissioner.
Okay. Commissioner Levitas.
Good afternoon, Mr. Smith. Bear with me. I've got a cold, as you can hear. So isn't it the case that the question of whether Duke should be deemed an owner under 62 110.92 depends on the details and the structure of the relationship?
Yes.
So, I mean, for example, would it be your position today that if Duke only owned 10% of this asset, they should be deemed an owner under the statute?
It depends on how the structure was set up. And I'm not pushing that that's what we would seek, a 90% ownership, but I'm saying that as long as they still had their controlling interest and the ability to move forward, providing reliable electricity, and grid operation, all that, then I think they could still be considered an owner under my sort of factor test in my head, based on the tax cases that I've seen.
So yeah, in the Blue Ridge case that you rely on, the court said that the balance that it balances the actual ownership interest with other factors, indicative ownership, and it mentioned the entity's control of the venture's operation, possible future increased ownership, and so forth. So don't we need to know something about those terms? Like, for example, who would operate the facility, who would construct it, what the details of the relationship between the parties would be?
Yeah, that would be included, and we're happy to file that in the RP bid proposal if we can move forward with the joint ownership for the commissioner review. But we don't seek to infringe upon what Duke's rights are under Chapter 62 and responsibilities. And so the way that we intend to move forward under sort of control issues related to operations, and sort of subcontractors, all those types of decisions that a corporate entity would make in a joint venture, we intend to sort of follow Duke's lead to the best interests of North Carolina ratepayers and under Chapter 62.
Well, to a point made by Chair Kemwright, doesn't that mean that we necessarily have to make a future decision about whether what the detailed structure that's proposed is sufficient for us to deem Duke to be an owner in a multi-factor test?
I think that the way I would look at it is that you're going to have to go through most likely some sort of CPCN type of proceeding anyway, where you're going to certify the project as necessary. And within that you're going to look at the constraints, considering how it's going to affect ratepayers, and whether it falls within what Duke's allowed to. And then when we look at a rate case and the future IRP, what that'll look like in terms of generation and asset planning and cost recovery. And all those Chapter 62 considerations will fall over. But in terms of, are we going to have to litigate this issue again? My anticipation is no. I think that we're going to go forward with a proposal that's going to beat the ceiling. And that proposal will include a consideration for joint ownership. And that we would like to partner with Duke in a way that they're comfortable with, that falls under that. Because this is a settled issue for them where they've asked to move forward with offshore wind. So we'd anticipate we'd be able to move forward in a way that would be beneficial for both parties, to bring it to the commission and not have to litigate this again.
Well, you may not dispute it between the parties, but excuse me, in order for us to do our job, we've got to see what the proposal looks like in order to answer the question, don't we?
Sure. And we would have no issue filing that proposal if you all think that would be a good, helpful step.
Okay, thank you for that. I just want to confirm, because I heard maybe something a little inconsistent. in several places in your petition, you asked that we rule that you not be required to submit a BOT proposal. And first of all, that was not included in your actual formal prayer for relief. And then I thought I heard you say maybe that's not an issue at this point. So I just want to clarify. Are you currently asking us to rule that you not be required to make a BOT proposal?
We are asking for you all to issue an order defining joint ownership so that we know whether or not the alternative submission would be available. If we're required to move forward under a BOT, then we'll move forward. We're prepared to do so. I'm not asking for the commission to make a determination on that, but I do think the determination on the joint ownership will make very clear what we can do and how we'll move forward.
I'm sorry, I'm not sure I'm following you. So my question is, are you prepared, are you asking us to relieve you of the obligation to include a BOT option in your submittal?
I am asking you to, I think by asking for joint ownership to be defined, we are in effect removing the requirement for the BOT. Because the way that we had understood the BOT and just in negotiating the RP, the extent we were able to negotiate, was a minimum qualifying submission required to do the alternative submission. But to say now that there could be joint ownership allowable, then I don't necessarily see the need for a BOT. If you all don't take a position and say, yes, you still have to do a BOT, but joint ownership is lawful, then I would suggest that we'll do both, but our more competitive bid will almost definitively be the joint venture.
Okay, and if we were to rule against you on the joint ownership issue, would you all make a BOT submittal?
Yes, we're prepared to move forward with a BOT submittal.
I want to understand a little bit more, maybe following up on Commissioner Hughes's question about the financing structure here, cost recovery. So are you suggesting that Duke would submit into its rate base its equity contribution as well as your equity contribution and then earn a return on that aggregate capital?
Yeah, effectively it'd be the total CapEx cost of the project. Within the fence, we're not looking to go outside to transmission or anything like that. That still would be followed under just Duke. But within the fence of the project, it'd be a joint ownership split with just equity, along with any sort of operations and construction contracts you can make related to it for the services related. But the idea would be a split that Duke would recover and then they would parse out the return between the two entities.
Well, I was under the impression that one of the purported benefits of joint ownership was reducing ratepayer risk.
Right.
So in that scenario, how is the risk to ratepayers of cost overruns or other problems reduced?
It's more on the front end of the project and the cash involved and the financing terms, I would say. If we have a equity split with a joint venture where each party is sort of assumed to cover, let's just say 50% of the costs up front and finance that side of it, then we think that would reduce the amount of cash that Duke is going to have to sort of finance for its projects.
That seems to me like a separate issue than ratepayer risk. It's sort of access to capital issue, which is not a trivial consideration, but it seems like a different issue.
I think that in my mind, it will funnel down through rate case and through the regulatory procedures. But your point's noted that this is most likely access to capital to which I see will ultimately impact ratepayer costs.
Yeah. Could you explain a little bit about why the joint ownership model is more attractive to your client?
Well, there's a number of reasons, but I'd say the first thing is having a long-term partnership with, as you can imagine, a construction and operations sort of aspect. We see ourselves as the experts on offshore wind, and we think that we would be the best at bringing in the folks to build and operate the project. And so, as you can imagine, offshore wind is one of the advantages of the operations costs across the life of the project are less than some of the thermal type projects, but there is still some operational costs. So there's something to be said about sort of staying in the project and getting some money out of that. And then it helps for Avangrid to continue to have an ownership piece of a project and be able to have that within their sort of list of projects that they have a piece of that when they go forward, sort of bidding out, getting financing, doing things going forward, saying, hey, we have a piece of this Kitty Hawk South Wind project.
Yeah, so you were just talking about construction. So who, in your view of this, who would actually build the project?
It will likely be subcontractors through relationships and folks that Avangrid and Duke may know that we can work together. And I would imagine there'd be some sort of preferred list of contractors. We haven't boiled all that down yet, but I do think that's the intent.
And who would manage that contractual relationship?
We see the way this working in the long run. And again, I'm sort of speaking over our RP bid proposal, but just to give you an idea of the way we see it, is that during the design and construction of the project, a lot of the control would fall on the developer's shoulders. And then during the operation of the project, while we would still be there to operate, it would fall much more on Duke's shoulders because at that point, they'd be delivering the electricity to their ratepayers. Of course, it's all subject to negotiation and we have open ears to hear what Duke has to say.
Thank you.
And Smith, I have a follow-up question based upon one of your responses to Commissioner Levitas. Commissioner Levitas was bringing up the same point that I had was asking about is how are we going to not have this be one decision, and if the commission were to provide the order that Avangrid is requesting, if we were to say that joint ownership is permissible under North Carolina law, when the proposal hasn't been submitted through the ARFI process, we don't know what the structure is going to be. And I think Commissioner Levitas gave the example of if Avangrid proposed 90% equity ownership and Duke had 10%, Duke might object to that and might take the position that that did not qualify as meeting the ownership requirement under 951. And I think your response is that those types of issues could be addressed in the CPCN proceeding for the wind facility or the rate case. But isn't what we're really doing here is determining the proposals that are then going to flow into the modeling and into Duke's next carbon plan proceeding? Isn't that really what we're talking about? And then if a offshore wind facility is selected by the model and the commission instructs Duke to proceed, at that point, the next steps would be taken, for example, submitting that application for CPCN. So to me, what we're trying to address right now relates very specifically to the next carbon plan application. And if Duke and Avangrid or Total Energies is not in agreement with the structure and whether it meets the definition of ownership or not in agreement with the structure that's been proposed with the details of it, how can we be assured that we're not going to have further delay and that this issue will be back in front of the commission again?
Thank you. So I don't want to be misconstrued. I think I look at the CPCN proceeding as sort of a blessing of the entirety of the promise of the project once the two parties are aligned. So I don't mean to say that this will be sort of out of the woods at that point, or I'm sorry, before that point. I think that the way that I see this happening is the way that it's contemplated in the RP, which is that, or I'm sorry, in the commission's order, which is that if the proposal beats that ceiling price, then the onus is on Duke to say why they don't want to move forward with it. And they have to do so, I believe, in writing to the commission. So there's already this sort of pathway where Duke could object to what's going forward with the offshore wind submission. What we're looking for is more on a very legal and sort of clarification as to whether or not joint ownership is allowed under 62.110.9. We believe Duke's taken the position that joint ownership is allowed with their CCs in Roxborough. And so why it's delineated differently for offshore wind is sort of where the rubber hits the road for us. Again, I know the deals are a little bit different, but ultimately the law doesn't care about off-take or whatever. It's about split ownership. And the dispatch rights for those CCs are meaningful in this discussion too. Ultimately, what we're looking for is that the commission in this proceeding issue an order saying whether joint ownership can move forward And then if joint ownership can move forward, we will create a bid proposal, hopefully in conjunction with working with Duke to move forward to say this is the best and sort of last, not best and last, but the best possible offer. See if it beats the bid, the ceiling price. And if it does, and if at that point Duke says, no, we don't want to move forward, then we will definitely have to probably come back up here because that's that we would want to fight against because we think it wouldn't be working in the best interest of the ratepayers.
And just again, as I mentioned when I first asked the questions, is that we have two different potential constructs. We have the split ownership, for example. I don't know what Duke's position. I'm going to ask them about whether they would agree that a split ownership like the Person County CC application would be permissible for an offshore wind facility. So that is one construct or proposal. And then the other is the equity share proposal that Avangrid is more interested in. And it seems to me that those are two very different constructs. And by the commission just making a decision whether co-ownership is permitted for offshore wind, I think it postpones the question or the decision about whether it's permitted for different types of structures for offshore wind. And I think that what you're asking for is just that legal definition. But my concern is that we're going to have additional litigation if we don't address the specifics about equity sharing as a proposal.
Understood. And I think what I'd suggest is that we'd be certainly willing to offer for the commission to review an RP bid proposal that includes joint ownership. And that would still fall in the timeliness of what we're looking at here to meet the IRP deadlines. I wasn't necessarily anticipating that would be the issue but if you all think that it would be necessary, we certainly think that that might be something that we would be able to do. Anything to do to help the commission be able to review and consider whether the ownership structure meets the requirements of law, we're happy to do.
Okay, thank you. Commissioner Tucker?
Thank you, Madam Chair. Mr. Smith, just a quick question. I know that we are here to determine whether or not split ownership or equity partnership is a real deal and whether it's allowed under 62-110.9. From a business standpoint, I'm looking at this from Duke and your perspective. In a partnership or split ownership agreement, first of all, Dominion's partner came in after the fact, after the project had been started because of perhaps cost overruns or uncertainties of risk to ratepayers, et cetera. We're on the front end of this now. Would not having a partner on a project this size, other than the de-risk that you mentioned, having a split ownership or equity partnership, does that not convolute the process? For instance, you mentioned a term sheet, you mentioned a list of subcontractors. Suppose Duke had good luck with some subs, some of the subs you had good luck with, some they didn't, some you didn't. I mean, how does this save money and convolute the process? It seems to me that in my partnership agreements in my business career, you've always got to think of what you want to do, you decide what you want to do, and then you got to go ask permission from the other partner on what you want to do and then argue from that point. You said the cost savings would not come on the cash side, it would come in on the front end side. I see on the front end side it getting convoluted and very difficult to work out, especially since this is their first major project. You say you know how to do it. We know historically what's happened to some of the wind projects and some of the ones that have been declined, decided not to go forward with, et cetera. How can you assure me in making a decision on the question of the day, split ownership or equity partnership, which is what you want this commission to decide? How can I feel comfortable with deciding one way or the other that I'm not going to convolute the process moving forward? If you can answer that, if you can't, I understand.
No, I think
Being a lawyer and never having, Brogan boots on and standing in the mud, I get that. I'm a normal person, I'm not a lawyer.
I used to move furniture a little bit. I got a little bit of blue collar in my background, believe it or not.
Great, great.
You know, I think that you hit on exactly the type of thing that I would say is a bonus, and an addition that we would bring. We are, Avangrid's interested in sort of investing in North Carolina as an offshore wind developer. We're multinational. We have developed hundreds of hundreds of megawatts of different types of generation across the world, again, including offshore wind. Rebuttal, the parent company, is $100 billion market cap. It's a giant multinational corporation that has all the experience in the world, and it also has all the efficiencies in the world that you can imagine with a company that big. Believe it or not, I know that kind of can be conflicting at times, but I can speak to the fact that what we're going to see here is something that's going to be streamlined and done in the most efficient process possible, where we use Duke's local knowledge as to what they need for their grid and our knowledge on the offshore wind side to sort of come up with a partnership that makes sense and moves forward briskly. You had mentioned that in your business background, that sometimes this can become convoluted, and that's something that we're really trying to look to eliminate. That's part of the reason that we're here today, is to try and move forward in a way that's going to allow the most concise sort of partnership agreement possible.
Okay, that's best you could do. Is a pretty good answer too. Thank you.
Mr. Smith, thank you for,
Ask one more question.
Commissioner Levitas.
This is following up on an earlier line of my questions. Have you considered, or would it make sense to consider a scenario in which your equity contribution to the project was not included in rate base and you were compensated? I mean, obviously, if it's equity, then it wouldn't be like debt where there was a fixed rate of return, but where there was some risk reward relationship that by which you were compensated, so that Duke would be passing through those costs, but not putting your investment into the rate base.
We have, and again, we're sort of at the relatively initial conversations on that, but I think that would be something if we thought that the commission or Duke would be more interested in that sort of setup. And this is something that once we have the joint ownership answer, I think that we'll be able to negotiate more freely with Duke and sort of talk about what that could look like in a way that makes sense. Because as much as I don't represent Duke or the utility, and so how they do their rate recovery and how they sort of parse out costs, I would want to defer to them and do what they think is their best practice.
Thank you.
Mr. Smith, we've had you up there answering questions for a long time. We've come to the end of it. So thank you for your responses. It was very helpful. And you may step down and we'll move to NCSEA.
Thank you.
Good afternoon, and may it please the commission. My name is Justin Smolowski. I'm appearing on behalf of the North Carolina Sustainable Energy Association, often abbreviated as NCSEA. The question presented before the commission today is not whether Avangrid or Duke Energy have a commercial preference regarding the contractual arrangement for procuring offshore wind, nor is the question presented whether Avangrid or Duke Energy's commercial preference will be more beneficial and result in more just and reasonable rates for customers. The question presented to the commission is a statutory interpretation of the North Carolina General Statute 62-110.9, and to ensure that that interpretation is consistently applied throughout the various proceedings before the commission. In its relevant part, 62-110.9 reads, any new generation facilities or other resources selected by the commission in order to achieve the authorized reduction goals for electric public utilities shall be owned and recovered on a cost of service basis by the applicable electric utility. As identified in the commission's final order in the initial carbon plan, docket number E-100 sub 179 at page 30, citing Midrix Text, the Department of Revenue, 369 North Carolina 250, the commission acknowledged longstanding precedent that a statute's language is accorded its plain meaning so long as it is reasonable to do so, and that adjudicating body should neither delete nor insert words used in the relevant statutory language. At its core, the controversy that brought us together today is Duke Energy's interpretation of 62-110.92 that the law requires 100% ownership of any non-solar generating resource selected as part of the least cost path through the carbon plan processes. On page 15 of Duke Energy's response in opposition to the petition, Duke argues that if the commission selects offshore wind or any other non-solar generating resource as part of the least cost carbon plan to serve the retail customers, The company shall own 100% of those resources. First, understanding that it is inappropriate for the commission to insert or delete statutory language of the relevant statute. Nowhere in 62-110.9 does it say that the applicable electric utility must have 100% ownership of a new generating asset, thereby eliminating the possibility of a joint ownership structure for procuring new electric generation. All the statute requires is that Duke Energy has an ownership stake in the asset and that is recoverable in its cost of service basis. And cost of service basis means can it flow through rates? As Total Energies identified in their comments, Duke Energy has successfully entered into joint ownership structures for large, long lead generation assets like nuclear generators in the past and have been able to successfully recover its costs through rates. And if you take a step back and look at what the statute asks more broadly, what does it mean to, what is ownership and cost of service when taken together? Essentially, it means that Duke Energy cannot enter into purchase power agreements with independent power producers to satisfy its carbon emission reduction targets as mandated in 62-110.9. Power purchase agreements are not passed through rates, and they do not always allow the utility to have sole operation of the facility. And to be clear, in other jurisdictions in the Northeast where some of the costs for offshore wind have seen struggles, those were procured through purchase power agreements through auctions, and PPAs were awarded to the winning projects. That is not what Avangrid's petition is asking for today. Avangrid is seeking a joint ownership structure. It is not contesting whether it is able to sell the power or capacity through its offshore wind facilities to Duke Energy. Moreover, if the commission agreed with Duke Energy that state law does require 100% ownership, it would not be reasonable to adopt that interpretation regardless. An adjudicating body can only adopt the statute's plain meaning if it's reasonable to do so. Duke Energy has multiple obligations. It has its fiduciary duties to its shareholders and its statutory duties to serve its customers safe and reliable service at just and reasonable rates while reducing carbon emissions. Joint ownership structures for large, long lead assets like offshore wind or advanced nuclear reactors down the road serve both these obligations and balances the interests of each group, shareholders and ratepayers. Long lead projects tend to be larger in scale, take longer to deploy, and that bakes in additional risk in pursuit of these resources. Having two financially stable parties collaborate in the development of such technologies helps secures better rates while financing and allows the utility to leverage less debt and equity. And overall, these structures support the financial health of the utility and gives it more flexibility to reliably serve its customers. And a lot of those arguments were reflected in the utilities' recent combined cycle application referenced frequently by Mr. Smith and approved by the commission in E2 sub 1318. To be clear, NCSEA is not contesting the commission's outcome in sub 1318 proceeding. NCSEA is just merely pointing out that as recently as last December, the commission determined that it was not reasonable to adopt Duke's 100% ownership interpretation of 62-110.9, and it allowed the utility to own less than 100% of the generating facility. One of the core distinctions here is we're talking about the statute requires ownership of the facility, not who has title and ownership of the megawatts generated by the facility. So if the commission has already determined that for select resources, that it is joint ownership ventures are reasonable, it should be attributed broadly to all potential resources in pursuit of the least cost path to carbon compliance. The commission identified that ownership structure does not impede Duke Energy's need for this facility as identified in the carbon plan IRP, nor does it impede its ability to solely operate the facility and dispatch and operate its grid. As NCSEA pointed out in response in support of its motion, there are factual differences between reaching the joint ownership of those combined cycle gas plants being proposed and some approved at the Person County Energy Complex and those of offshore wind facility. But as Mr. Smith also identified, factual circumstances are still subject to the letter of the law. And here we see the regulated utility arguing for different interpretations of the same law due to these factual distinctions. The parties in support of Avangrid's motion are not asking for special treatment. We are asking for consistent treatment to increase the certainty through these procurement processes. The other point that NCSA seeks to impress upon the commission is to consider what is the asset actually in question. The value is not the electricity that may ultimately be injected into Duke's electric grid from these ultimate offshore wind facilities. It is the wind energy area itself. In some of the commissioner questions from the previous oral argument by Mr. Smith, it was asked about CVOW and how does that distinguish? Well, the difference is that CVOW owned its wind energy area. It successfully bid into the federal processes and procured that lease. And as a result, it was able to start development of it unilaterally and then determine after the fact it needed a joint financier to help reduce the risk and limit its exposure. Here, the inverse is happening. Duke Energy, as made clear through its through cross-examination in the last Corporate Plan IRP proceeding, does not own it in wind energy area. Therefore, a contractual arrangement needs to occur in order for it to gain access to this potential offshore wind facility. What NCSE has seen is that an overly prescriptive minimum qualifying submission that was invented by Duke Energy does not capture the full value of the wind energy area. It is trying to capture the value and price point Duke seeks to acquire that wind energy area. Much like in Duke's comments in opposition to Total's motion for a limited reply, Duke says that it is inappropriate for Avangrid and Total to try to dictate how Duke conducts its business to solicit info through the RFI. It is equally inappropriate for Duke Energy to try and dictate how other entities manage their duly acquired property, and it is risking the integrity of the ARFI. As pointed out in NCSA's response and support, starting on page 12, contractual arrangements require mutual assent. Avangrid has made clear through some of its initial statements that a build, own, and transfer is not its preferred pathway, and it would seek a alternative pathway through joint ownership. I think part of the issue there also ends up in the fact that the alternative pathway still requires, as dictated by the ARFI, transfer of ownership prior to this project being placed in service. So at the end of the day, is there an alternative pathway for Avangrid to seek its preferred path? Again, we are dealing with two corporate entities that each want to conduct their business and serve their fiduciary duties to their shareholders. We are looking for what is the best price that Duke Energy can procure offshore wind, but that doesn't mean that Avangrid needs to sell or Total Energies needs to sell to Duke Energy. And I think that's our concern by including this minimum qualifying bid for support. If that does turn out, despite Mr. Smith's contentions that he feels like the joint ownership structure will be more beneficial and more cost effective, if the inverse were to occur, I find it problematic that the ARFI will not result in binding information. It will be an exercise in information that will not lead to procurement. By incorporating these prescriptive requirements that may not be the preferred pathway and get one party to sell to the other, definitely hinders the commission to receive some of the ability that is likely to lead to and hinders the commission's ability to receive information that is likely to recede to procurement and just get a bunch of options for modeling. But we want to find the best data available to most inform the modeling. And given that the commission authorized Duke to incur $1.4 million to conduct this ARFI, if it is putting restrictions that may not result in the best information, there's questions raised about the stewardship of that monies and how that is going to be passed through to ratepayers and having to reconduct this process time and again. One other thing, talking about whether or not the redressability of this issue will be resolved by the commission's ownership, that joint ownership is allowed under statute. Duke Energy in its response pointed to the fact that in its alternative pathways, it requires the developer to demonstrate in a future RFP issued after the ARFI is concluded and prior to the date and responses are due in any future RFP that such joint ownership structures comply with both the 2023 CPIP order and applicable ownership requirements under North Carolina law. So even though today, pre-ARFI, we are seeking a declaratory ruling on whether joint ownership is viable or not, whether or not it gets to the procurement or CPCN for offshore wind, if we move forward to an RFP, this question is going to arise again if there's disagreement. And there's no clarity provided by the commission on its statutory interpretation and allowing the ownership structures. And Duke's main protest to the offshore wind facility being jointly owned is that it is not allowed under North Carolina state law. In its comments in opposition to the petition, it did not really opine on any of the benefits or drawbacks of a joint infrastructure. It just merely rested its laurels on the fact that it is not allowed under North Carolina law. We need more clarification and an interpretation of this live and contested issue before the commission, and it falls squarely within the Utility Commission's statutory grant of authority to interpret state law, and that falls within its jurisdiction. I have not been keeping track of my time, but I'm finished.
You still had some additional time, but are you, I believe you said you were through with your oral argument?
I was, yes.
Okay, thank you very much. I just have one question, and then I'll see if any of the other commissioners have questions. The same question I asked of Mr. Smith. Are you aware of any BOT structures for offshore wind that are present in the United States?
As I mentioned, I am not aware of any BOTs that are present in the United States. As I mentioned, most of the Northeast procurements for offshore wind, those are auctions, and the award at the end of that procurement to the winning project is a power purchase agreement to serve the electricity and capacity into a utility or our ISO RTO service territory. And to distinguish again from the one other differentiating structure model is the CVOW project up in Virginia. Again, state law determined that there was a need for offshore wind.
Mm-hmm.
And one of the things that state law facilitated was the Dominion Energy having a wind energy area lease itself to begin its initial development phases. So there is a bit of an ability to self-build that Duke Energy does not have in the present matter. And what was still recognized and acknowledged through that CVOW project was that there is substantial risk in a joint financier, and a joint ownership structure does benefit ratepayers and reduces exposure to risks and insulate both shareholders and ratepayers.
Okay. Thank you. Let me see if there's any questions from the other commissioners. Okay. Thank you very much.
Thank you.
So let's go ahead, if it's okay with the court reporter, we will hear the oral argument and then take our morning break. We'll hear from Total Energies. The afternoon break.
Madam Chair, Commissioners, may it please the court or the commission. My name is Robert Josie with the law firm Nelson Mullins, representing Total Energies, Carolina Long Bay in this matter. This commission has a subject matter jurisdiction over this matter and can and must determine that joint ownership is allowed under the statute, which is clear from the plain language of the statute and Duke's own actions. Further, the ability for Duke to take advantage of joint ownership structures is in the best interest of the ratepayer. Now, I'm probably going to go back over some of what you've already heard today, but hopefully I won't bore you too much. The commission must rule on this joint ownership issue now, because not rendering a decision would frustrate the commission's CPIRP order, which requires the RFP to be issued contemporaneously with the ARFI report if the ARFI bid proposals come in below the reference price. There's a clear controversy as to the interpretation of Section 110.9. Duke believes it is unable to co-own a facility under that statute, and the interveners obviously disagree and believe co-ownership is allowed under the statute. Duke's argument in its pre-hearing filings as to Total's position that should the commission render a decision on the joint ownership issue today, if it would affect Total's decision whether or not to move forward in the process, shows that there is no case or controversy, is a misunderstanding of Total's position. If a decision is made today on the joint, a definitive issue, definitive decision on the joint ownership issue, Total could potentially not move forward in the RFP process, or at least in the RFP process. It would likely still go forward in the RFP process. But if no decision is made today, then Total will move forward with the process, but we'll be right back here in a few months asking this exact same question. And we will be having these exact same arguments all over again, and we'll have wasted a lot of time. And the standard for whether or not there's a case of controversy is whether or not it will avoid further litigation in the future, which a decision on the joint ownership issue certainly will, and that's from the Supreme Court's own standard in NC Consumer Power. As for the plain language of the statute, it clearly, from Duke's own actions, allows for joint ownership. Duke argues that the plain language of the statute clearly requires Duke to solely own resources because they are the only entity that can recover a cost on a cost of service basis. But despite their insistence on reading every word of the statute and looking at it as a whole, their actions show that they have failed to do so themselves. Section 110.9 states, any new generation facilities or other resources selected by the commission in order to achieve the authorized reduction goals for the electric public utilities shall be owned and recovered on a cost of service basis. In its argument, Duke combines generation facilities and other resources into just generation resources. And that's just not what the statute says. The statute says any new generation facilities or other resources, which, giving meaning to all the words of the statute as required in mid-rex text versus NC Department of Revenue from the Supreme Court, any means all generation facilities or every generation facility. Roxborough is clearly a new generation facility. It's still under construction, it's still being developed. And the commission even says in its CPCN it issues the CPCN for a 1,360 megawatt natural gas fueled combined cycle gas combustion turbine facility. Second, or other resources, again, giving meaning to every word of the statute, means resources other than new generating facilities. Therefore, Roxborough cannot be an other resource. If Roxborough is not considered a new generation facility, then I don't know what would fit that definition, therefore rendering the new generation facilities portion of the statute meaningless. Therefore, if you're going to read the plain language of the statute, as Duke argues, Duke must solely own all new generation facilities, which would include Roxborough. And that's clearly not the case. I want to be clear that I'm not arguing that Duke is violating the plain language of 110.9 by co-owning Roxborough with NCEMC. What I'm arguing is there is only one way to read the plain language of the statute that does not violate the rules of statutory construction and interpretation, and also allows Duke to co-own Roxborough. And that is to read ownership to include partial or joint ownership. Once that issue is taken care of, once you understand that ownership includes joint ownership, then you can read the rest of the statute to allow Duke to recover its portion of its ownership portion of the facility on a cost of service basis, just like it plans to do with Roxborough, just like it does with every other joint ownership asset it has. And that is giving meaning to the entire statute and each word in the statute. Furthermore, joint ownership is in the best interest of ratepayers, as we've seen from the Commission and the Supreme Court time and time again. In the Catawba nuclear case, the Commission stated that the Catawba sales agreements, which included a joint ownership agreement, benefited retail ratepayers by enabling Duke to complete the nuclear facility without having to issue substantial sums of additional debt and allowing other joint owners to finance their share of the plant at a lower capital cost than is available to Duke. And the Supreme Court confirmed or affirmed that decision, stating that the reduced cost of building a nuclear plant due to the municipal and EMC financing advantages and current low embedded cost of Duke's debt compared to what it would have been had Duke been required to sell bonds. Another example where the Commission has allowed for alternative ownership structures was in the Carolina Power and Light case in 1974, where a bank wholly owned 11 combustion turbines in the Darlington, South Carolina facility and leased them to CP&L because it was the most desirable means of obtaining permanent financing. Furthermore, joint ownership does not violate any North Carolina policy set out in 62-2. A joint ownership structure can help promote adequate, reliable, and economical utility service by spreading financing costs across multiple entities. A jointly owned facility does not result in the duplication of investment, economic waste, or inefficient service. Joint ownership would lead Duke could possibly lead Duke to borrowing less if the joint owner can help provide additional financing advantages. The Commission has been concerned over the last several years about Duke's access to capital. In the last two general rate cases for DEP and DEC, they set an ROE at a level that they believe would allow Duke access to the capital it would need to complete the CPIRP plan. But even at the time, former Chair Mitchell thought that it wasn't high enough because they were so worried about making sure that they meet the requirements of the CPIRP statute. And we all know that even a small movement in the ROE can have a big impact on retail ratepayers. Depending on the terms of the joint ownership agreement, Duke could have to borrow less money initially for the purchase of the facility. And again, depending on the terms of the joint ownership agreement, Duke could potentially pay less for the use of the other portion of the facility than if Duke owned and recovered the cost with its added rate of return. This would save ratepayers money, and Duke would still be able to recover its ownership stake on a cost of service basis. Again, Total is not requesting the Commission issue an order on a specific type of joint ownership structure at this time. Total believes the Commission should rule that the plain language of the statute clearly allows joint ownership, and that the Commission should require Duke to accept and evaluate joint ownership structures in the RFP and any subsequent RFP. The Commission should also state that it will evaluate potential joint ownership structures in either a CPCN or a pre-construction cost approval process through 110.6. It should set out a list of factors that we'll look at when determining whether or not to approve that ultimate joint ownership structure. And we laid out, I believe 7 different factors in our brief, but just quickly, whether the level of control of the utility over the facility meets the regulatory requirements, 2, the possibility of the utility increasing its ownership stake throughout the lifetime of the facility, the effect on the total cost of the facility, other ratepayer benefits, as the effect on the quality of governance and functioning of the facility, risk sharing, and the effect on the utility's ability to access capital, and then the effect on operations and maintenance of the facility. And with that, I'll open it up to questions.
Thank you, Mr. Josie. I mentioned that we would take our morning break. I meant our afternoon break. So we will take a 12-minute break, and we will come back at 3 o'clock with questions.
Thank you.
Thank you. We'll go off the record. Mr. Josie, thank you for your argument and your presentation. I will have fewer questions for you because Mr. Smith answered most of my questions, but I will ask some of the same questions to hear Total's position or perspectives. Starting with the question I asked Mr. Smith, I asked a lot of questions of Mr. Smith about the actual controversy that we have here. And I heard your argument that we have an actual controversy about the definition of ownership. And my question though is again, is it ripe for decision with the commission since we don't yet have the proposals from either Avangrid or Total Energies? And so before I ask you to respond to that, what alternative submission, if you're able to share with the commission, what will be the proposals that Total is going to be providing? Is it going to be a split ownership like the Person County CC facility, or is it going to be an equity sharing joint ownership? Are you able to tell us what Total is planning?
Well, I initially would say that talking too much about the RFP submittals actually violates the RFP itself due to the confidentiality terms in the RFP. What I can say,
do not say anything that would violate any confidentiality.
what I can say is that, no, Total is not looking at a split ownership like Person County. If I understand split ownership to be, they're going to sell part of the facility to Duke and then sell the keep part of it and then sell the electricity to some other entity. That's not what Total envisions. There's not really anyone else, given the nature of where the wind lease area is, that they could sell to. What I could say is that I think they've contemplated ideas like a capital lease or something similar to what we've seen in the CP&L case, where Duke would own a portion of the facility, Total would own a portion of the facility, but again, it would come down a lot to the terms of the joint ownership agreement, and maybe they could lease a portion of it, and that way it would flow. I know there was a lot of questions on how this would flow through rates. That wouldn't go into base rates. Duke wouldn't be able to get its rate of return on Total's portion of the facility because it doesn't own it. And that would be could potentially be a savings to ratepayers because it would potentially be lower than Duke's return on equity. So.
And for those types of proposals, it's going to be very specific to the actual terms of the proposal. And so help us to understand how we are not going to have another proceeding before the commission because, for example, let's just say the equity sharing arrangement that Avangrid was discussing, and I'm just throwing numbers out there because I don't know what would be anticipated, but if based upon, let's say, the Roxborough CC facility where the North Carolina EMCs own 16.54%, if the proposal for the equity sharing was that Duke owned about 16% and Avangrid owned the remainder, then I think we would be there could be a disagreement about ownership. So without seeing the proposals, how is this controversy ready for the commission to be determining whether the ownership requirement in the statute has been complied with?
Yeah, totally understand your viewpoint on that, but I think the biggest issue here is that Duke, through its filings in this case and in the RFP, state that it doesn't believe that it's legally allowed to not own 100% of any facility. And so in order for them to even begin negotiations, I mean, this is totally understandable from a Duke perspective. They're trying to be careful. They don't want to violate the law. But this case is right now for this ownership issue because it would allow Duke to begin to accept, evaluate joint ownership proposals, whatever they may be, in whatever form they may be. And at that point, once the parties are able to negotiate the contract structure and the procurement structure and things like that, which all was in the CPIRP order, things that Duke was to engage the wind developers on. It's been difficult. I'm not saying they haven't engaged, but it's been difficult to have conversations on exactly what those joint ownership structures look like because Duke is understandably not quite willing to go that far just yet. And we have to have a decision from the commission on whether or not ownership is allowed at this time before we can move forward. And anything, I mean, this commission will see this joint ownership structure again. Should it allow for joint ownership is permissible under the statute, Duke and the co-owner will likely come in before construction starts to have the joint ownership structure blessed by the commission in either a CPCN proceeding or a pre-construction rate recovery proceeding, as I mentioned before. And at that time, the commission would be able to evaluate a number of different things and weigh those options. And we gave the commission a list of factors they could look at. It's very similar to determining whether or not something is or isn't a public utility. It really depends on the specific facts and circumstances of the case. We can't get there without this commission issuing a ruling on the joint ownership issue.
And no, I don't want to belabor this point any further, but one last question about this. So during the ARFI process, that the proposals are presumably going to be information that is going to be included in Duke's next CPIRP application. Is that your understanding as well?
I think that's part of the process. If the RFE proposals will be looked at with reference to the reference price. If it's under the reference price, then an RFP process will begin to take place according to the commission's order in the last carbon plan hearing. And so that process will be kind of paralleled with the CPIRP process that's going to start fairly soon. So yes, it will go into the modeling, but assuming that the RFE report says, yes, there should be an RFP, then we're going to go forward with that process. And again, assuming that process starts at the beginning of August, I believe, then we need a decision on the joint ownership very soon because as you've seen in the negotiated language that Total and Duke came to in the RFP, even if Duke, takes these alternative submittals with joint ownership, before an RFP can be, RFP bid can be put forward with a joint ownership proposal, we have to have a commission order stating that joint ownership is allowed.
And just one more question about this, because I want to make sure we're all clear, and I think I'll put Duke on notice. I'll be asking the same question. But if Duke and the wind developers disagree with the proposal about the specific proposal, whether that meets the statutory ownership requirements, and so then that issue presumably would have to be litigated by the commission at a later date. How does that impact the CPIRP process and Duke's application and the modeling? Will that cause delays? Will that cause practical difficulties for Duke's application? And also, is that something we should the commission be concerned about that?
I'm not sure how concerned the commission should be about that. I mean, I think the thing we want to focus here is getting this process right. And, obviously the modeling and the CPIRP process is a big part of that because it brings in the entire picture. But again, if the RFE results come in below the reference price, we will be procuring offshore wind. We just don't know how and, necessarily maybe how much. But we will be doing it. I mean, that's how I read the commission's order in the CPIRP docket.
And the same question I asked of Mr. Smith about timing. So Avangrid has asked for a final order on this issue on or prior to April the 28th, because the deadline for the ARFI is April the 29th. If the commission were to issue an order by April the 28th, what is Total's position about that? Will you be able to submit proposals into the ARFI process the next day, or do you need a 30-day extension as well?
My understanding is that Total would still be able to provide both a build own transfer and an alternative submission on that timeline. However, of course, we would gladly take an extra 30 days to refine everything, knowing for a fact that joint ownership is allowed, or, in the alternative, it's not. And again, how that affects the timing going forward, I don't know how long it'll take for Duke to take the RFE results or the RFE proposals and turn them into the RFE report. That's something you'll have to ask them. I do think it's imperative we get this right. And so a small delay at the beginning is less significant than delays down the line when we're really trying to move this process forward and getting, RFPs and things like that going.
Okay. And my last question is the same question that Commissioner Levitas asked of Mr. Smith. Is Total planning to submit a build own transfer proposal in this process?
That is, if we are required to, then yes, Total will do that. And that's why Total negotiated the language. I know a question you asked Mr. Smith about the stakeholder process. After the second meeting, which I do believe was, at the request of the public staff, we had a long discussion in the second meeting on the joint ownership and whether or not it was allowed and whether or not we were going to be able to submit joint ownership proposals. And at the end of that meeting, after that meeting, Total actually reached out to all the parties, including Duke, and presented some language to start the negotiation on what ended up being in the RFE. So, allowing some sort of alternative submission. Obviously, we would prefer to just submit one preferred joint ownership submission, but if required, we will submit both.
Then one last question. I didn't want to repeat all the questions that I asked of Mr. Smith due to timing. From the questions that I asked of Mr. Smith, are there any of his responses that Total disagrees with or would like to provide a different response? So that I don't repeat all of the questions, is there anything that you disagree with that you want to point out to the commission from his responses?
I do not think I necessarily disagree with anything he said. Again, the types of submittals that Total may submit could possibly be different than what Avangrid submits, things like that. But, again, I think we've touched on everything. Of course, I can't remember exactly every question you asked.
Okay.
But,
Thank you.
yeah.
Commissioner Brawley.
Thank you, Chair. Mr. Josie, good afternoon.
Good afternoon, Commissioner Brawley.
As I understood, you made reference to 2 bank-owned CTs in Darlington, South Carolina that were leased to Duke Energy.
11.
Oh, it's 11 of them.
Yes.
Okay. How does the transaction in South Carolina impact North Carolina law?
This commission approved that transaction, stating that CP&L would it would be better for the CP&L financing. This was at a time back in the 70s and 80s where Duke was building, or Duke and CP&L at the time were building a lot. Same time as the Catawba nuclear facility is being built, and the access to capital they needed to build these facilities was a serious concern. And here, CP&L, this commission allowed CP&L to lease wholly owned combustion turbines, 11 wholly owned combustion turbines, wholly owned by the bank, because of the access the bank could get to capital and financing, which alleviated some pressure on CP&L and their ratepayers.
Would you by any chance have that docket number?
Yes, it is in our comments. I believe it's E2 sub 244, but I can confirm that if you give me a minute. Yes, E2 sub 244. The order was issued on June 7th, 1974.
Thank you, sir.
Yeah, absolutely.
Commissioner Tucker.
Thank you, Madam Chair. Counselor, one question. If Total was successful in a joint partnership was allowed here, I think I heard Mr. Smith say that Duke would have 100% rights to dispatch and that all the energy would be used in North Carolina. Is that correct?
From a Total perspective, again, we'd have to negotiate those terms. I think Duke, all of the electricity would be sold into Duke Energy territory. I think that's almost a certainty from a Total perspective, again, given where its wind lease area is. Exactly, I would assume Duke would have control over the dispatch of the facility, given, again, it was going to be on their grid. But there could be quirks to it based off of the negotiated terms of any kind of joint ownership agreement.
Well, I got a quirk with it going north of North Carolina. I would want the energy to be used here.
I don't think there's any doubt that it's going to be used in Duke Energy territory.
Okay, and that's fair, and I think Mr. Smith stated that as well. Let me ask, you cited the 74, the E2 sub 244 about CP&L financing 11 CCs by the bank. That example to me is not what we're talking about here. I know that the bank quasi-owned it. They just were financing money. They didn't run it. They didn't do anything, wasn't involved in the construction, et cetera. So I don't know that pairs up with what we're trying to decide here. Can you, since you're citing examples, 40 years ago, 45 years ago, have you been able to cite any examples where this commission has told Duke Power, Duke Energy, Progress, DEP, how to run their business? Meaning they take on a project, and such as the Roxborough project, Person County project, and they build it, they finance it, and then they determine that they want to give NCEMC a piece of it. Did we dictate that to them? Is that what you're implying in citing that? I'm trying to look, you're asking the commission, I think, to tell Duke, okay, it comes to wind exclusively, you've got to have, the law's states that we decide that the law states that Duke could have joint ownership if they chose to. But what you're asking, if I understand it, and you can tell me if I'm wrong, but we're telling, by making this decision, and if we were to make the decision on a joint partnership, we're basically telling Duke what they've got to do with their own project. And this would be a precedent for Duke.
So I understand where you're coming from, but that's not exactly what we're asking here. Again, we're just asking for the commission to rule that joint ownership is a possibility for Duke. It's just it would just be another tool in their toolbox in trying to lower risk and money, to ratepayers. Here, if joint ownership was allowed, Duke, we're not asking the commission to say, Duke, you have to negotiate with them to come up with a joint ownership agreement. What we're asking is joint ownership be just is allowed, and that the RFP process and the RFP process can include joint ownership bids. And if we're allowed to submit joint ownership bids, and those are at the best cost to ratepayers, I would hope at that point Duke would see that and want to negotiate a joint ownership contract in the best interest of their own customers. But there's nothing, we're not asking the commission to require Duke to do that. We're not asking the commission to say that the commission must require joint ownership, just that it's a possibility. It's another tool in the toolbox in trying to serve Duke's customers at the least cost.
Okay, and as Mr. Smith said, the savings would be on the front end, not so much on the cash end on the backside.
Most likely, again, that completely depends on the joint ownership agreement. But what we cited in our comments was the idea that, again, Duke's going to be having to borrow a ton of money to meet the CPIRP requirements. And if a joint owner could help alleviate some of that burden on the front end, maybe Duke doesn't need quite as much access to capital. Is it possible that lowers the ROE? I can't guarantee that by any means, but it is a possibility. And again, any movement in that ROE, any less burden Duke has on needing access to that capital in the markets would be beneficial to ratepayers.
Just one more state clarity. So if you submitted or joint ownership was allowed to be a possibility as an interpretation of North Carolina law, and the numbers came in and your numbers as split ownership or joint partnership, whatever you want to call it, if those numbers came in the best, you would hope Duke would choose that, but they would not be obligated to do so, right?
Correct. Duke would
Okay.
not, if a joint ownership proposal wins an RFP and Duke decides to choose an RFP proposal that included 100% ownership and did not win the RFP, they are more than free to come to this commission and try to get that project approved in a CPCN or cost recovery process.
Okay, thank you.
Commissioner Levettis.
Thank you. So, Mr. Josie, aren't we dealing with a two-part question here, which is, on the one hand, a legal interpretation of the statute, and on the other, a prudential decision about what's in the best interest of ratepayers? In other words, when I look at the factors that you cite at page 17 of your comments, you suggest those not coming into play until a CPCN proceeding. But there's some of the similar factors that are referred to in the tax cases relied on by Avangrid. And it does seem to me that there is a legal question, I think, that has to get answered before the prudential question about whether a joint venture proposal would be in the best interest of ratepayers. Unless you're taking the view that there's some sort of absolute test that, say, I asked, threw out 10%, that that the legal question was if Duke owns any percentage of a project, that satisfies the statutory language. And it's all then kicked to the prudential phase of the discussion about what makes sense. Is that your position, that there are no factors, there are no details that are relevant to the legal determination?
On the whether or not joint ownership is allowed under 110.9, no, there are no factors involved in that. It's simply how do you interpret ownership under that statute. I will say that those factors show that joint ownership could be beneficial to ratepayers, which is a North Carolina policy under 62-2,
Right.
which, you know, you could read as a whole along with and in harmony with 110.9 as we believe it should be interpreted.
Well, my question though is, isn't there more of a legal question to be answered than just whether there is some scenario in which joint ownership is allowed legally? In other words, is the percentage relevant? Is the control relevant? The other factors that you cite as a legal matter, just as it was in the tax cases. That was a question of law in the tax cases where the court said you have to look at these other factors to decide whether we're going to deem this party to be an owner. And so my question to you is, do you contend that the statutory requirement of Duke ownership is satisfied if there's nothing more than a nominal percentage of Duke ownership, or are there other elements of the legal test before you get to the prudential test of what's in the best interest of ratepayers?
Okay, so if I understand your question correctly, again, what Avangrid is asking the commission here is a determination on whether or not joint ownership is permissible under the statute. When we talk about whether or not Duke owns a facility, we're going to need to look at some factors, but that's going to be a question that's answered further down the road once we have more facts and circumstances around the joint ownership agreement itself.
Okay,
Those
so
facts-
you,
yeah.
excuse me, I didn't mean to interrupt.
No, I was going to just say those facts and circumstances would look at the actual joint ownership itself once
So-
it's more fully baked.
Okay, so you would be satisfied if the commission did nothing more at this point in time than to say, there is some world, there is some scenario in which joint ownership is permissible, but we're not going to say yet whether any proposal that you might make is legally allowed and satisfies the statute.
Yes, I think we'd be satisfied with just a determination that joint ownership is permissible under the statute. And until we get that, it's very difficult to move forward with this process.
And when do you think the legal decision with respect to the more detailed structure would need to be made? I can't imagine you want to wait till a CPCN proceeding to make that legal determination.
I mean, I think it could be, technically, it could be brought at any time prior to construction of the facility. As you say, that's the absolute last moment it could be brought, because I don't think Duke or any potential joint owner would want to start construction on any kind of jointly owned facility without approval of the commission that some of those costs are going to be recovered. But yes, at some point when the joint ownership agreement is more fully fledged out and discussed and has been negotiated and agreed to, at least in some sort of term sheet for perhaps the RFP, then we could, bring it before the commission.
Thank you. You said at the outset that you thought that it was clear from the plain meaning of the statute that joint ownership was allowed. This is an ambiguous statute, is it not?
It's ambiguous if you're just reading the plain language on its own, but if you take the plain language of the statute along with Duke's actions in the Roxborough situation, then there's only one way you can possibly read that statute under the statutory construction, statutory interpretation, and allowing Duke to co-own any new generating facility.
Yeah, that's where I was going to go. It seemed like your argument was really not that the statute is unambiguous on its face, but that Duke's co-ownership of Roxborough can't be reconciled. I think your position is with their reading of the statute.
Yes. I apologize if there's any confusion, but yes, the plain language of the statute is ambiguous as to the ownership portion. But when you combine it with Duke's CPCN in Roxborough to co-own Roxborough with NCMC, that's when it becomes very clear that there's only one way you can read the statute.
Thank you. My last question, I believe you said something during the course of your argument that suggested you were thinking about a different model than the one I understood from Mr. Smith, and specifically that you don't necessarily envision that the total equity contribution to the project would simply be put into Duke's rate base.
I mean, that is one of the options that Total has been considering is can it own a portion of the facility and be compensated for Duke's control over that portion of the facility. And if that's the case, then it likely wouldn't be able to run through rate base. It would be more of an expense.
Yeah, is there any precedent for third-party equity contributions to a utility being incorporated into the utility's rate base?
Well, contributions and how that works, I don't know of any off the top of my head, but again, the CP&L case allowed a bank to wholly own 11 generators and CP&L to lease them. So
But how did CP&L cover the cost?
I will admit it's an old case and I was unable to, it didn't come up in the proceeding, the next rate case. So I'm not exactly sure how it goes through, but my understanding of how it would go through would be it would be an expense and not in rate base.
Yeah. Thank you.
And I have one follow-up question that I know Commissioner McKissick does as well. This relates to what Commissioner Levitas just asked. You talked about that you're just looking for a decision that co-ownership is permitted so you can move forward with the submissions, and that the determination would occur at a later time about whether the specifics of the proposal or the structure, whether it meets the definition of ownership. But isn't it possible that in the ARFI process, if a submission is provided to Duke and Duke objects to the structure and says that if the commission were to say that co-ownership is permitted, but Duke says that this does not, the details or the structure does not meet co-ownership, this issue will be potentially back before us ahead of the CPIRP proceeding. Am I missing something?
That's definitely a possibility. I can't say that you're wrong that, you know, if Duke were to say, okay, now that we know joint ownership is permissible, but we're not sure this joint ownership, you know, I guess proposal meets the definition of a statute. Yes, could we be back? I mean, I would hope that situation wouldn't happen, but yes, I can't say it's not a possibility. We're lawyers, tend to litigate. So.
Okay, thank you. Commissioner McKissick.
As lawyers, sometimes I think that we look at the world from a variety of angles and make it as complex unnecessarily as possible. And with that said, the only thing you're seeking today in this petition for declaratory ruling is to clarify ambiguity that's in a statute. And by clarifying it, the simple issue you want to resolve is that co-ownership is permissible without anything further at this time, so that we know that it's not precluded and it's not impermissible.
Yes, that is the absolute number one thing that Total would like to see out of this proceeding, out of a commission order. I would say that we would like to also have a requirement that Duke accept joint ownership proposals in both the RFP and any subsequent RFP. But first and foremost is a determination on the ownership issue.
And I guess the only other issue that has been put forward, but from hearing from various counsel today, it sounds like that issue is not as preeminent in your mind, is that in terms of the build to own, to transfer model, that is a model that you're prepared to go ahead and submit a plan for, even though you're going to be moving forward with an alternative submission as well.
Exactly, Commissioner McKissick, and that's why we negotiated the language that's currently in the RFP for the alternative submittal.
So we make a decision dealing with that, the primary issue about the co-ownership. You guys are fine. We can deal with everything else that come forth later when proposals are submitted and all of it is considered and potentially negotiated at an appropriate time at some later date.
Yes.
Thank you.
Commissioner Levitas.
I think I found the answer to the question I asked you a minute ago and related to Commissioner McKissick's question. I'm looking at page 14 of the RFE, which deals with alternative submissions. And this is language that you negotiated with Duke, correct?
Yes.
So what the condition that is stated here is that after the RFE is concluded and prior to the date that responses are due to the RFP, then the party has to demonstrate that the joint ownership structures comply with the requirements of North Carolina law.
Yes.
So that seems to answer my question about when this determination is going to be made under this language that you negotiated.
Well, again, we negotiated that language. We'd obviously like a commission determination as soon as possible. I think that would be in the benefit of every party. Duke would know exactly what RFP submittals it can and can't accept, or at least would evaluate. And if we were able to, but if we were able to get a determination prior to RFP submittals, that, that's what we were able to negotiate, knowing Duke doesn't believe that that joint ownership's allowed.
Right. But we've already established that we can't make the ultimate legal determination without having the details of the proposal.
Yeah.
Okay. Thank you.
Thank you, Mr. Josie. That's all the commission questions. We appreciate your argument.
Yep. Thank you.
Okay, so we will turn to Duke now.
All right, well, good afternoon, Chair Cameron, Commissioners. Good to be with you today. Good to have a chance to speak to these issues, and we've had some really helpful discussion. I think it's clarified a lot of points this afternoon. So today I'm going to address two principal questions in my comments. First, I'm going to explain why the motion should be denied because there is no sufficient controversy to support issuance of a declaratory order. Avangrid invites you to serve as its general counsel as it seeks to advance its business interest in constructing offshore wind generation, and you should reject that invitation. And I'll say on that point that I think, as we've heard today, there are so many aspects of what is potentially being proposed that are not right. There are so many major questions about the structure of these arrangements that simply have been unanswered in the questions that you've answered. And those incomplete answers, the incomplete details have only served to highlight how unripe this issue is for your determination. The second issue I'll address is the substantive issue before you, and I'm going to explain why, consistent with your prior findings, the HB 951's utility ownership requirements are clear and unambiguous, and they should be applied in accordance with their plain meaning. The General Assembly said what it said. It said it very plainly and clearly, and it's our job as a utility, your job as a commission, to follow the clear directions from the General Assembly. All right, so let me start with the question of whether there's an actual controversy here for this commission to render a declaratory order. To be clear, we feel very strongly about our position on the substantive question, but we do believe the commission needs to follow the law as it relates to declaratory order standard. And that standard requires there to be an actual controversy. And there's a reason for this standard. It's intended to protect this commission and courts from unnecessary and time-consuming litigation on an issue that's not ripe for decision. Your calendar is incredibly full. Your dockets are overflowing with matters to handle. And this standard is put in law in North Carolina to protect your time and your resources from having to opine on an issue that's not ready. and that you will likely face potentially future litigation on it, or alternatively, never actually have to resolve this issue because other circumstances transpire. And that's the reason for having a threshold procedural requirement before you issue a declaratory order. And an actual controversy is not just a difference of opinion. We clearly have a difference of opinion on what the law means here, but there has to be something more than that for this commission to issue a declaratory order. And as we think about what is required for you to issue a declaratory order, I think the most instructive case for you to look at would be the Q-Biadkin proceeding. It's a proceeding that we talked about in our comments. And I think it helps to have a little background on it. So I'm going to roll the tape back to the basic facts of that case and then how it played out in litigation. So in Q-Biadkin, a business, Q-Biadkin, with a preferred business plan, they approached this commission. They asked this commission to tell it whether or not their preferred business plan was consistent with the law. That was their request to you back in 2019. Duke Energy opposed on the substantive question. So we entered the proceeding, we opposed on the substantive issue before you. And the commission ultimately did choose to act on the substantive question before it. They issued a decision and they sided with Duke Energy on the substantive question. That case was then appealed to the Court of Appeals. And when it got to the Court of Appeals, there was a bit of a curveball because the Court of Appeals found there was not a sufficient controversy for this commission to render a declaratory order on that set of facts. Essentially, what the Court of Appeals said is it's not the job of the courts and it's not the job of this commission to provide advice to a business about whether their preferred business plan is consistent with the law. And if that sounds familiar, I think it should, because that's exactly what we're here doing today. We have a business who has a preferred business plan and is asking you to tell them, serve as their general counsel, tell them if their preferred business plan is consistent with the law. And that's precisely what the Court of Appeals concluded in Q-Biadkin you should not do. So the question again of whether there's an actual controversy in a North Carolina law, if you dig too far into the case law, it can be a bit esoteric and depending on the facts, a little hard to parse out. But again, if we come back to the Q-Biadkin decision, I think we can find some really helpful touch points for you to think about applying to this set of facts before you. And in the Q-Biadkin case, one of the judges framed the issue this way. They said, effectively, they said, what are the ifs before we reach the really core dispute in a case? What are the condition precedents? What are the ifs that have to be resolved that could either lead to the litigation or potentially lead to a scenario where the litigation is totally irrelevant and a decision is not needed? In this case, in this scenario, there is a future point in time at which an actual controversy could arise. And it's likely at that point in time in which offshore wind has been more definitively identified by this commission as part of the least cost plan. And we are prepared to proceed with authorizing construction. And we're then determining who should own the asset and how it should be structured and what North Carolina law says with respect to this. But there are innumerable ifs that remain before us before we ever get to that point in this process. And again, those ifs could lead a lot of different directions. It could lead us potentially to having to come back and ask very similar questions to you again, because the issues right now are not ripe. It could also lead to a scenario where we don't have to ask this question of you because other answers to other questions lead us down a different path from a resource plan. So let's think about the ifs that are still before us before we really have a true controversy on this topic. We need to complete the RFE. We need to evaluate all of the myriad of factors that may have changed over the last year that may affect the viability of offshore wind, that may affect the cost effectiveness of offshore wind. We likely need to conduct further modeling. We need to better assess and understand all of the parameters of the bids we receive. Authorizing the construction of offshore wind generation in North Carolina is a $5 or $10 billion decision. That's not something that's going to happen quickly or lightly. And we are quite a ways away from when that decision is really before this commission in a real and meaningful way. As you ask very great questions about deal structures and arrangements and financing, again, our perspective would be the answers you got today were very vague. They were not fully baked. They were not the kind of things that really lead us to a position where we're ready to make the core fundamental decisions on offshore wind. And in fact, they would tell us that we're quite a ways away from those real meaningful decisions where we actually need potentially you to weigh in on these issues. So in summary, we don't believe there's sufficient basis in this case, if you look to the QB-Adkin precedent, for you to render an advisory opinion to a business who wants to know if their preferred business plan is consistent with North Carolina law. So with that issue aside, let's turn now to the substantive question of the statute here. And so if you were to disagree with us on this point and conclude there is an actual controversy, that we then need to address the substantive question. Again, our perspective is you don't need to get to the substantive question because there's an insufficient basis for declaratory order. But if you do, we want to address that topic as well. So you've heard it, the statute already, and you've got it in your procedure order, you've heard it many times, but it's so critical, I think, to ground ourselves in the actual words on the page. So the HB 951 ownership requirement says this: any new generation facilities or other resources selected by the commission in order to achieve the authorized reduction goals for electric public utilities shall be owned and recovered on a cost of service basis by the applicable electric public utility, except that, and then the statute goes on to list two specific express exceptions. The first being an exception for existing law applying to EDSM resources, and the second exception providing a very detailed ownership percentage split, down to the exact percentage the General Assembly wanted to split ownership of solar resources, 55, 45%. And when statutory language is unambiguous, it needs to be applied according to its plain meaning. You yourself, this commission, found that that language was in fact unambiguous. And from our perspective, the plain reading of this statute is so clear. It's really a testament to the creativity of the bar, of the attorneys in the energy bar in the state, that we're having a disagreement about this at all. If a ordinary person picks up a statute and it says something this clear, the utility shall own and the resources shall be recovered on a cost of service basis, the most natural read is exactly what we have argued it to be. And it's Avangrid and the other parties in this case that urge a reading that actually requires words to be implied into the statute. Now, very briefly, I want to just provide a little bit of color on the policy behind this directive from the General Assembly. We actually spent a good amount of time in our 22 carbon plan comments explaining the policy, the policy benefits of utility ownership and cost of service recovery. And so I won't belabor all those points here again, but I'll make two very basic ones. Of course, the statute doesn't explain the policy reasons behind, but there are very significant ones that I think support this policy. The first is that utility ownership, direct utility ownership, provides the simplest way for this commission to oversee the enormously complex task of the energy transition before it in the carbon plan and ensure the number one goal of that plan, which is a reliability. You know exactly who to call if the plants have problems. You have direct insight in their operations, their cost. All of those reasons give you utility ownership. True full utility ownership gives you the ability to have that direct control. Cost of service rate making. That is the most clear, transparent, easy to understand way for us to know that customers are getting the exact value they deserve for the dollars that we spend on this energy transition. In cost of service rate making, you see every penny we spend. You assess our cost of capital. You evaluate every decision we make to make sure it's reasonable and prudent. There is a host of benefits that come with cost of service rate making that provide meaningful policy benefits for the state of North Carolina. In the comments from the other parties, you've heard a lot of conclusory statements that third-party ownership de-risks these investments, that it provides very unspecified and unquantified benefits, that it may lead to lower costs for customers, but there is literally no objective evidence of the math or the analysis behind those conclusory statements. Our experience has shown that in many cases, utility ownership is actually cheaper than third-party ownership. And it certainly provides the clarity and transparency that I just explained before. So I think the cursory and simplistic assertions that have had no background evidence to support them in this proceeding should be very much discounted in this case because that has not been established in any meaningful way. Now, let me come back to the words on the page of the statute and think a little more about what's the most natural read of the statutory language that the General Assembly gave to us in HB 951. Again, I would tell you if a layperson picked up those words and read them, they would believe that this was intended for Duke to have ownership. Ownership means full control, full ownership of the asset. But if you need to apply sort of statutory constructs, I think all of those also lead us to that same conclusion. And there's three principles of statutory construction that I think can be brought to bear here. The first is, under North Carolina law, it's very well established that when the legislature enumerates an exception to a statute, one can infer that they do not intend for any other exceptions to be made to that statute. And so how does that apply in this case? Well, as I said at the outset in introducing the statute, the General Assembly said utilities shall own and the resources shall be recovered on a cost of service basis. And they took the further step of including a very specific, very express exception. And they took the time to explain the percentage of resources that should be owned with respect to that single exception. And so under this principle of statutory construction, we can know very confidently that there are no further exceptions that were intended by the General Assembly with respect to utility ownership. And we'll cover this point in a little more detail here, but the arguments you've heard create wide, massive exceptions to the ownership by suggesting that something as small as a 1% ownership share could satisfy the statutory directive. And that is not consistent with the principle, not consistent with how the General Assembly drafted this, where they did take the time to explain the one exception and did not identify any other exceptions to their directive. A second statutory construction principle that can be brought to bear here is that any interpretation that would render a statute meaningless or nullify the statute effectively is strongly disfavored under North Carolina law. Again, I come back to some questions that Commissioner Levitas asked here about what is the limiting principle on the interpretation that Avangrid and these other parties are urging with respect to ownership? There is none. They have suggested effectively that an ownership arrangement involving as little as 1% or maybe 10% was the number shown could satisfy the directive for the statute. And that would effectively nullify the statute. It would make no sense that the General Assembly would say so clearly the utility shall own and shall recover on a cost service basis, and yet have the outcome be the utility owns 1% of the generation. And so their interpretation has no limiting principle. It could lead to sort of completely rendering it meaningless, and therefore it's not a valid way to read the statute. A third and final statutory construction tool that must be brought to bear is a very basic one, and that's the conjunctive construction of this statute. And that's just a fancy lawyer way of saying and. There's a big and right in the middle of this. The ownership arrangements and the resource selected must both be owned by the utility and recovered on a cost of service basis. Any arrangement in which any portion of the resource is not being recovered on a cost service basis is not consistent with law. And I will say on this point, as you asked very insightful questions about what is being proposed by these parties with respect to cost recovery, I got to be honest, I had a hard time following exactly what the proposals were. It hasn't really been explained, but nothing that was described sounded like classic, traditional cost of service rate making. I haven't heard Avangrid or Total's indicating they're willing to come to this commission and provide the enormous level of detail about their costs that utilities have. I haven't heard them say they're willing to come and demonstrate their cost of capital, their cost of debt, all the things that go into cost of service rate making. None of that has been communicated as being acceptable to these parties, and therefore their proposals don't meet the second requirement of the statute. They're not true recovery on a cost of service basis. And that is a full requirement for any generation and all resources under the carbon plan. So let me turn now to the examples that have been cited supposedly in support of their positions. And let me start first with the NC-EMC arrangement. And this is an incredibly critical point. It's a somewhat fine distinction, but I believe with all due respect, that all of the attorneys who spoke to this issue fundamentally missed the distinction of the NCEMC ownership arrangements. Let me try it again. We explained it in our comments, but we'll try it again here. The question we need to ask ourselves is, to what resources does the ownership requirement of HB 951 apply? Right, so HB 951 says for resources selected as part of the carbon plan, the ownership requirements apply, ownership and cost of service. Does NCMC have a carbon plan? Are they directly subject to regulation from a carbon emissions perspective? The answer to that is no. NCMC is not directly subject to the carbon plan. This commission doesn't issue a carbon plan for NCMC. They issue a carbon plan for Duke. NCMC is not directly subject to regulation under HB 951. And so their portion is not technically part of the carbon plan, and therefore is not subject to the ownership requirements specified under HB 951. That's the distinction. That's the distinction. 951's ownership requirements only attach to resources that are part of the carbon plan. NCMC's slice of the plant, which, to be very clear, is not providing kilowatt hours to Duke Energy customers. It is providing kilowatt hours to NCEMC's customers. NCEMC's customers pay the full cost of that resource. Only Duke Energy's slice of the CC is provided to North Carolina retail customers and is subject directly to the carbon. And so that's the core distinction why that ownership requirement, that ownership arrangement is consistent with the law, and others that have been proposed today would not be consistent. There's another second factor.
Mr. Drack, your 17 minutes is up, so if you could wrap things up very quickly, please.
I will say very briefly, there's other factors to consider in NCMC. The other examples cited by the parties with respect to Darlington and the co-ownership of Catawba, very simply, those things happened before 951 was passed. The General Assembly is free to change its policy. It's free to enact new directives. The directives in 951 did not exist when those arrangements were established. It exists now, and it's our job, your job, to follow the law as it exists today going forward as you develop your resource plan. So in conclusion, thank you for your patience. We continue to believe there's no justiciable controversy here sufficient to support your issuance of declaratory order. And if you get the substantive question, we believe the law is abundantly clear and the plain reading is consistent with our interpretation. I'm glad to take questions at this time.
Okay, thank you, Mr. Drack. I'll begin with a couple of questions and then turn it over to my fellow commissioners. I'm going to start with your argument about that actual controversy does not exist, and you referred to the Cube-Yadkin case in oral argument and in your comments. I'm familiar as well with the Cube-Yadkin order. Help me understand. I view the Cube-Yadkin order, the Court of Appeals order, as being different from what is before us today, because the Cube-Yadkin decision stated that there was no actual controversy at that time because it was, in essence, a proposed business plan. But what we have here is we have in the ARFI on page 14, under section 7B, the alternative submissions, we have language in the ARFI that states that, however, all proposals must at least transfer ownership no earlier than mechanical completion, but before the project is placed in service. So we have a requirement under the alternative submissions about utility ownership that the Avangrid and Total disagree with the interpretation and believe that that is in violation or does not comply with 951. So can you reconcile the difference between a proposed business plan and Cube-Yadkin and a requirement in the ARFI?
Yeah, thank you. And I would start with the fact that the utility should have wide discretion, and we can speak to this more depending on where the questions go. But the utility, to Commissioner Tucker's earlier point, needs to have a great deal of discretion on how it chooses to structure potential transactions and things like the ARP. So we have structured in a way that both is informed by HB 951's ownership requirements, as well as using our business judgment to structure this RP. And as I mentioned earlier, the key issue here is the ifs that will remain after we receive these bids. So we have agreed again to accept bids that involve joint ownership, and they're free to submit it. But it's also our discretion to say we demand that folks submit these bids that are conforming with the minimum qualifications. And what happens after that point, remains to be seen. There are innumerable uncertainties as we sit here today about what happens next, where the prices land, what federal policy factors influence what ultimately happens with offshore wind. What are the rate impacts we're looking at for customers? There's going to be a lot of things yet to be determined that could keep this ever from rising to a true litigated controversy before you. And for that reason, we think you should refrain from weighing in at this point and not encourage this type of premature legal action.
But Mr. Durack, if the commission did not issue, if we were to agree with you and took the position in our order that an actual controversy did not yet exist, and the Avangrid and Total submitted alternative submissions that allowed joint ownership as they are proposing, then what would happen? Those submissions would be rejected. Is that correct? I mean, they would not be considered as part of the ARFI because they would not be meeting the minimum requirements for the alternative submissions.
So that they will not be rejected. We are receiving those bids, and we're going to receive the totality of the information submitted to us as part of the RFI, evaluate it, and use all of that information, all the bids, to inform the modeling we do for the upcoming CPRP. So we absolutely intend to evaluate it and take it into account as we form up modeling assumptions for the next CPRP. And as you heard today, both of the parties, if you were to take no action, as I understood the comments today, both parties intend to submit both the minimum qualifying bid as well as the alternative bids. So if you do nothing, this RFI is going to proceed, and there may be a future dispute. There may not be. There are many things that could occur going forward that could lead us to additional disputes or could lead us away from additional disputes. But it is not critical for you today to issue a decision based on the comments that you've heard from the parties.
And Mr. Durack, I just want to make sure I'm clear on this point. I think that what Avangrid and Total are particularly concerned about is if they provide alternative submissions that do not, my understanding from their arguments is that their alternative submissions would be more cost competitive and would be more likely to come underneath the blind reference price. And if they do not provide, so if they were to provide submissions that allowed co-ownership, is Duke going to consider that information when it does its modeling? Even if Duke's taking the position that does not meet the minimum requirements, what happens with that information and that the cost competitiveness, and how is it going to be used or not being used in the modeling for the carbon plan application?
It will absolutely be used in the model. As I said earlier, we will receive the totality of the information provided by the bidders, and we will look at all of it. We will assess all of it, and we will synthesize it to the best of our ability to come up with what we believe is a reasonable representative price going forward for modeling in CPI.
And if this is not yet an actual request for proposals,
Correct.
what is the purpose then if you're going to consider this information? Why is this ownership, disputed ownership portion included in the ARFI? What is the purpose of that then if we're not yet at the procurement stage and you're going to consider the information if they submit it, or perhaps they won't submit it because they are not meeting the minimum requirements? But help us to understand how this is practically going to work.
Yeah, so we are under the terms of your order in the CPRP and in the stipulation. Our job is to receive bids in the RFI. We're seeking to structure in a way that gives the most meaningful, up-to-date, and as binding as possible information. But once we get that information, there's a next step. Obviously, if all the bids are above the reference price, then the next step will definitively be further evaluation of CPRP. But importantly, there's another big step there, which is that we need to assess all the dynamics that have changed in the marketplace and in policy space that may impact the viability or cost effectiveness of offshore wind. And so that's still a determination that remains to be made after we have this information, and that will be reported to you in our July 31st report on the status of offshore wind. So there's a range of scenarios that could come, but some of them involve not needing to resolve this issue, and that's the exact point of the justiciable standard under the declaratory order.
And let me move on to the Person County CC. And you stated in your argument that the Person County CC facility is different, and the North Carolina EMC's ownership of the Person County CC is not subject to the carbon plan because they're not a regulated utility, and that they are going to be selling the output for their portion of the ownership of the facility to to their wholesale customers or to non-Duke retail customers. But wouldn't that be the same situation if it was co-ownership of of an offshore wind facility in which let's just say hypothetically, Avangrid owned a portion of the facility, even though they've said this is not their intent to do this, but if they owned a portion, let's say hypothetically, 25% of the facility, and then they delivered the power and sold the power into PJM, wouldn't that be the same situation as a Person County CC?
It would be, and that would be permissible under North Carolina law. Again, the distinction goes to this commission's job in the carbon plan is to select resources to serve North Carolina retail customers. Those resources, or that slice of that resource that's part of the carbon plan, is subject to the carbon plan's ownership requirements.
Mm-hmm.
If it's not in the carbon plan, if it's NCEMC serving their own customers, if it's another co-owner selling into PGM, if it's somebody selling into any other balancing authority, you don't regulate the emissions of that plant from a carbon plan perspective. Therefore, it's not subject to the carbon plan's ownership requirements.
And if that were the scenario, then it would be up to the parties to negotiate the share of ownership, and there would be it would be up to the parties to determine that. It would be potentially anything that the parties could determine, no matter what the split is, if they were able to make that determination.
Correct. And you would have the recourse, because it has to be cost of service recovery. The slice that goes to North Carolina retail customers, you would have the right to look at it and say, is that a fair, through the benefit of cost of service rate making, would look at it and say, am I paying the appropriate cost for this resource for North Carolina's portion? So you wouldn't have that right with respect to the other portion, but you don't need it because you're protecting North Carolina customers.
Yeah. So from your response, I think that co-ownership of an offshore wind facility is permitted under, based upon what you've been saying, under specific circumstances. Would you agree?
The very specific circumstances that I've articulated. Correct.
Okay. And then for the scenario in which Avangrid would like to proceed, which is an equity sharing of the generating facility. Does Duke currently have any generating facilities in which it has an equity sharing arrangement with a third party?
I'm going to speak from my knowledge. I'm not aware of any situation where there's an equity sharing arrangement of a plant that is wholly dedicated to North Carolina retail service. So I'm not aware of one. I have not reviewed every single plant in our system, but I'm not aware of one.
And if you go ahead, no, please proceed.
I would make the point again here that this is really the first time we've had any meaningful discussion. I didn't read much, if any, detail in the comments about what is even being proposed, and yet we're here in this room hearing for the first time of loosely defined equity sharing, where there's maybe some of it goes in rate base, maybe some of it's not in rate base. And to me, that just highlights we're not ready for a decision. As I sit here today, I can't articulate what's being proposed by either of the parties. They seem to be a little different at times. Sometimes they seem the same, but there's no meaningful, clear description. And again, we're talking about major, massive decisions for the state of North Carolina, billions of dollars. some of the most complex transactions you could possibly imagine, complex financing. We have so little detail in this proceeding about what is actually being proposed. And again, that just highlights the sense that we're kind of putting the plane together as we fly in this room. And that's just not the way to go about this kind of decision. And certainly not a basis for a declaratory order.
And following up on that, Mr. Jack, I know your position is that this issue is not ripe for determination. Avangrid and Total, they want a limited decision, just that co-ownership in some form is permissible under House Bill 951. If the commission were to be making a decision, what do you believe that the commission would need to have the actual submissions in front of it to make those decisions? Or would a statement that some form of co-ownership is permitted under 951? What would be the practical consequences or difficulties if the commission were to say, we agree that some form of co-ownership is permitted under 951? What would be the harm to doing that?
Well, without further color from the commission, without a lot of detail from the commission, we, Duke, would not know whether we agree or disagree with you, because as I've explained, in the very narrow circumstances, we agree co-ownership is permitted. And so you would need to give a lot more color on what exactly that means, but yet you really haven't been given the raw material to give us that direction.
Mm-hmm.
So I would say you have not received the type of information that would allow you to render a meaningful decision on that topic. And again, it highlights that this issue is not right for you to wade into those waters. Again, especially considering there is a scenario where this question never comes back to you again. That's a scenario where there are, let's say a major federal policy change that puts a moratorium on offshore wind 5 months from now. We are not projecting that. We're not saying that's going to happen, but there are scenarios where we can say definitively, it's not the right time for North Carolina for offshore wind. And at that point in time, you wouldn't have to decide this issue. And again, that's back to why this standard exists. When there are ifs before the real heart of the question needs to be answered, then you shouldn't wade into it.
Okay. And then I just have two more topics I want to ask you a question about is the stakeholder process that I asked some questions of Mr. Smith about. Can you provide Duke's position about whether Duke complied with the directive and the CPIRP order in regard to the stakeholder process?
Yes, we absolutely complied with the spirit and the law of your directive in that respect. And we appreciated the meaningful engagement from all the parties. And that stakeholder engagement doesn't mean you agree on everything, but we even on the points we disagreed, we came up with a meaningful resolution to allow the RFP to move forward. So yes, we complied absolutely with your direction in that respect.
And then my last question is the Avangrid and Total have requested essentially like a 30-day extension to submit their alternative submissions after the commission issues an order. Can you talk about timing? What effect would a delay in any submissions to the ARFI? What is the practical effect of that?
Yeah, I would tell you it would be very problematic to be faced with that delay at this point in the process. I can't tell you definitively. We can't complete the next sequence of events. I can't say that definitively today, but I can tell you the schedule internally that is moving towards our update, CPRP update to you, is incredibly tight, and it's very difficult to absorb delays in the sequence of things we need to happen, and this is one of those sequences of things. And 30 days is going to be very difficult for our team to absorb and still meet the deadlines in front of them.
Okay, thank you. Let me see if Commissioner Tucker.
Thank you, ma'am. I'm going to ask an obvious question that I sit and listen. You know how I am about things. Suppose we were to not grant the petition for a declaratory ruling, and that would give the favorability to your consideration of 951 and 100% ownership by Duke of the wind project, et cetera. If that is the way this comes down, what would prevent Duke or preclude Duke from entering into, at a later date, a scenario much like Dominion and their partner came after the fact? You know, Duke manages enough debt now. I think we'll all agree Duke is faced with more debt coming, trying to interject the renewables and to do what we need to do with the carbon plan, et cetera. And you're going to have to borrow a lot of capital to do a major wind project. You use the number 5 to 10, and I think 10's the better number based on what happened with Dominion. What would preclude you from taking on a partner at a later date as you delve into the construction process and parameters change, capital excess is different, carrying what you're carrying on the balance sheet, they wouldn't let you borrow any more money and you need to move forward with the project? What would preclude you from taking on a partner or joint ownership at that juncture?
Yeah, let me start with just acknowledging the challenges in front of us that you've spoken to, we've heard discussion about before. And while there are major challenges, I'm also incredibly confident in our team and our ability to deliver on the commitments and the obligations we have to the state to balance these challenges. I know we have the best in the business out there raising capital to provide the reliability that we're required to provide under this plan. And I know that you all understand the challenges, and that I'm confident we can work with you to sort through it in the most optimal ways that needed. And we're going to take it one step at a time. And you've told us we need to focus on customer rate impacts. We got to focus on reliability. And that's where our focus is. So I can say from a big picture perspective, I'm very confident we can navigate through these coming years together in a way that benefits the state as a whole. And to that point, you know, certainly if there's a point in time at which it's really necessary for something like that to happen, we're going to be aware of it. We're going to see it coming, and we can make the General Assembly aware in the right ways that maybe that's the best thing for the state. But for the time being, we need to follow what the General Assembly said, that they saw policy benefits for North Carolina in the ownership directive and in the cost of service directive. So we're going to follow that for the time being. But I will definitively tell you in the future, if it becomes clear that we're missing out on some customer benefits, that's something we're going to be open to. But we're going to be looking for the General Assembly to give us that direction. And we always have a voice down there. We can communicate that if that's in the best interest of customers. But again, for right now, our job is to work with you, implement the carbon plan, and to do it in accordance with the law as it's written today.
Well, thank you for those comments. They may come back to you at some later date on another project, but I appreciate what you're saying. But yeah, I mean, you may have to, just like Dominion. I mean, with all the other parameters that we have with renewables and the transition by 2050, et cetera, there may be that time when someone else has more capital, which has been alluded to by the petitioners to, you know, that could happen, but you know, that's not the message for today. I just thought I'd ask about partnership down the road.
And I just want to affirm again that thanks to your constructive regulation, we are well positioned with an incredible credit rating. We do some of the lowest bond issuances in the utility space. We have access to capital because we're a financially healthy utility. So I think if we keep on this trajectory, we don't see in the near term any challenges doing what you're asking us to do. We obviously will keep our eyes open, keep our ears open to the best way to benefit customers. But we're well positioned to execute. Not saying it's easy, not saying it's not complex, but I think we're well positioned to do it and on a trajectory to execute well.
Kissick.
Mr. Jurak, you don't believe this issue is ripe for consideration at this time? And your contention in saying it's not ripe for consideration is that there are not proposals that are forthcoming that should be put forth to us for consideration. Is that an accurate assessment?
That's part of it, yeah. I think you've really seen today that there is that the cake is not fully baked on what you're being asked to opine on. And so that is an additional reason why I don't think this decision is right, but there's others, and that includes the fact that future litigation on these questions is not guaranteed. As I've said before, there are a lot of ifs that are going to occur after the RFE. Some of those could lead us down a path where we make different decisions about offshore wind. And those could lead to a situation where we don't need an answer to this question in the future. And so again, that goes to the question of whether there's an actual controversy that's needed to avoid certain future litigation.
Do you believe there is statutory ambiguity that needs to be potentially clarified at some future date by this commission? Or do you believe that that's an issue that ought to be resolved by the General Assembly?
Duke Energy's position is that the statute is not ambiguous. And that is what you found in your order. You said directly, the statute is clear and unambiguous. And I would tell you, if someone picks up that piece of paper and says, and they're not an attorney, so they're not wired in the odd ways that we're wired. They just read the words, utility shall own and shall recover on a cost service basis, and then identifies a single express exception. Our argument would be that plain reading is utility has full ownership, and that it's the folks that want to tell you it's partial ownership are really the ones reading in words, because you have to believe it says shall partially own, and for that portion that's partially owned shall be recovered on a cost service basis. You got to read all those words in the statute for it to make sense under their interpretation. So I think ours is the one that doesn't need new words in the statute. Their interpretation really is reading in new words, and we know you can't do that when interpreting the statute.
But in the original carbon plan decision, and I think it was Avangrid's counsel that referred back to footnote number 9 and the fact that the ownership issue was not being resolved at this time. Yeah. Do you not believe that based upon that, as well as what I can see as potentially ambiguous language, that there be a reason to resolve that issue at this time in terms of whether some form of co-ownership is permitted?
I can't speak for what the commission had in its mind when they put that footnote in. But my belief is they were wrestling with the same issues that I've addressed here with respect to a Roxborough-like co-ownership arrangement, or an arrangement where the co-owner is not using their portion to serve North Carolina retail customers and is therefore not directly subject to the carbon plan. So that arrangement, that distinction is such a crucial one, and it is the exact reason why our position on this issue has been consistent from day one, and yet we believe that Roxborough co-ownership. Again, to summarize that issue, the carbon plan's ownership requirements only apply to resources that are part of the carbon plan. NCMC is not directly regulated by you. They don't have a carbon plan, so the ownership requirements don't apply to their portion of the plan.
And I understand that distinction that you're making, and I acknowledge that distinction that you're making. I guess the question is that controlling in my mind?
I believe it is. Again, our position would be shall own and shall recover on a cost service basis is unambiguous. What potentially you were looking to explore is the type of ownership arrangement we're describing here, which doesn't go to the question of what ownership means. That's clear. It just goes to the question of what's in the carbon plan and what's not in the carbon.
And I guess my final question is simply this: wouldn't it be in everyone's best interest to go ahead and clarify that issue now, as opposed to going through the RFE and waiting for proposals to come in? So at least, everybody understands what the thoughts are of this commission at this time. Would there not be advantages in doing so to help eliminate what has emerged as an issue of contention between the parties that are here today?
Again, I think it goes to the complexity of what you would be saying, and the fact that I don't think you have the raw material to say anything that's going to avoid future disputes potentially. And then it also comes back to the core issue of there's a reason for the declaratory order standard. There's a reason for that threshold. And I don't think you want to encourage this kind of question before you that's not right. And if you choose, I don't want to go too far on this point, but if you choose to issue the decision, you choose to kind of entertain this question here when maybe it's not really ripe. At some level, you're encouraging future actions like that. And at some principled way, I think you should think long and hard about whether you want to kind of lay a pretty firm standard that your time and resources are pretty scarce. They're very valuable. And we don't want to be using them up on something like this where future litigation is not certain, or future litigation is just going to continue because we can't really resolve the issue today because of the lack of clarity we have on the plans.
But there is the potential, depending upon the resolution of that issue, that it could save time down the road.
I would say very directly, it's unlikely a decision here is going to save time. Because you're not going to be able to solve every possible configuration that could have to be litigated down the road. Or we could end up in a scenario where we're never going to have to answer this question anyway. So I don't necessarily see you saving time by choosing to entertain this Nelson ratio decision. Again, that is your call. We feel very confident in the law. If that's where this commission lands, we understand that, but it's an important threshold issue that you should consider very strongly.
Oh, I understand and respect your position. Thank you.
Commissioner Levitas.
Thank you. Good afternoon. With respect to this issue of timing, I wanted to refer you to the language in the RFE at page 14 that I asked Mr. Josie about, which seems to require that this issue be, do you need a minute to look at that?
I'll describe you.
It's a requirement, as I understand it, it's right here in black and white, that for a developer to submit an alternative proposal, that they have to demonstrate after the RFP is concluded and prior to the date of any response to the RFP, that a joint ownership structure complies with applicable requirements under North Carolina law. So haven't you established a sort of outer date by which we have to answer this question? And why would you want to go through an RFP without having this question answered?
Well, again, that goes to the point I was discussing earlier, which is, as we sit here today, it's not a guarantee that there will be an RFP issued.
Fair enough.
And so in that scenario where a market development, a policy development that has occurred or will occur here in the next month or two leads us to the conclusion that it's not the right time to issue an RFP, then obviously this requirement is punted down the road. And that's the exact kind of thing that the declaratory order standard is saying is, if you're looking at a fact pattern, if there's a fact pattern in the future where you don't have to answer this question because of a condition that occurs, then don't answer the question. And that's exactly what we're saying could very well occur with respect to this provision.
Thank you. I understand your position on that. My point was just, this is not an issue by your own terms that would be deferred out into the indefinite future. Assume if there were to be an RFP, your language requires that there be a legal determination of this issue in advance of the RFP, correct?
I don't disagree, but that then takes you to the question of what is the ownership structure you'd be opining on right now? And we don't have that in front of us.
Understand.
Sorry.
Let me ask you one other thing about the RFP, and then I'll come back to the ripeness issue. There's I think one of the parties may have raised this issue, so I just want to clarify it. In the fifth line of that section on alternative submissions, it seems to contemplate two types of alternative submissions. Some that are.
Could you just refresh my memory what page you're on?
I'm on page 14 under section B, alternative submissions.
Sorry. If you give me one moment.
I think it was an exhibit to your comments.
Sorry.
It's all right.
All right, I think I'll be there momentarily. All right, I'm with you. What page are the RFP?
14, top of the page.
All right.
So you're with me?
Yes.
So you have minimum qualifying submission requirements, and you allow alternative submissions, which presumably don't fully, you say may alter some aspect, but then you say they do have to provide for transfer of ownership no earlier than mechanical completion. You see that?
Mm-hmm.
I'm assuming that doesn't refer to the joint ownership proposal, because that would be inconsistent with the idea of joint ownership. In other words, that language about transfer prior to mechanical completion isn't meant to eliminate or conclusively decide the joint ownership question. Is that fair?
I think that's fair. Is that correct?
Okay, I think there might have been some confusion from one or two of the interveners about that, so thank you for that. So, excuse me, Cube Yadkin, wasn't the issue there really that the company Cube Yadkin didn't have sufficient controlling interests in the project that it was proposing to make the case justiciable? I think the court said that it was like somebody wanting to have a basketball game against Duke, but they didn't have access to the arena. And so the analogy here would be if these companies didn't have, say, leases, control of the property, and so they were really in a speculative mode about whether they would ever be able to do it. And so it seems a very different situation than what we're dealing with here, at least with respect to the facts in Cube Yadkin.
Yeah, I think we would view that the facts are similar in that Cube Yadkin had some assets, had control of some things, not others. So there was aspects that were sort of buttoned up into their control and aspects that weren't. And I would tell you that sounds a lot like what we're faced with today. Yes, they have a lease, but do they have a fully formed plan for the ownership arrangement, their proposal? Do they have a fully priced out resource? I think there's just a lot of uncertainty about what you're being asked to opine on, and that was exactly what Court of Appeals found in Cube Yadkin.
So turning to the 2022 carbon plan order, I may have missed it, but I don't see the word unambiguous in that order. But in any case, you mentioned several times that was the finding that we made. But in any case, the issue that was presented there, as you know, was whether it was permissible for there to be assets other than the 45% of solar in which Duke had no ownership interest. That's what the interveners, the parties there were proposing, is that you have PPAs with out-of-state assets with no ownership by Duke. And so that was the specific issue. And the commission said that the plain language did not allow that to occur, which I think is certainly an understandable decision. And then you have the footnote saying, but we're not deciding now what ownership means. So I don't know that I really, have a question. You, I guess, have suggested that you think this decides the issue. I don't read it that way. I think it left the ownership issue to another day.
That's fair. I respect that opinion. I do think there was a lot of other kind of questions around ownership other than that specific one you identified that the commission was resolving. But I take your point that your view is this wasn't resolved.
And in a similar vein, with respect to the specific statutory exception that you've spoken to about 45% of solar, again, that's an exception that allows a situation where Duke has no ownership interest in the assets, right?
Right.
So different question than joint ownership.
But it goes to the principle that the General Assembly did take the time to expressly identify that exception in a very great amount of detail. So one could infer it did not intend for other exceptions.
That's right, with respect to no ownership by Duke. So turning to the statutory language, I guess as an initial matter, you would agree, wouldn't you, that if you and I bought a house together, we would both be owners of the house? And just lay definition of ownership does not imply 100% ownership. We talk about owning stuff all the time. So that in my mind, just from the lay definition, there's some question there about what ownership.
Yeah, I don't know that I would fully agree with that. I think the average layperson, when they hear that someone owns something, assumes that the default assumption, I would say, of the ordinary reading is 100% ownership. I would have to explain, it would be an odd, if I told someone I have a house, they would assume I own it. They would not assume I co-own it with a friend. I think I would have to explain it to them. Well, actually, it's kind of a unique situation. I co-own this house with my friend.
Well, you do, if I guess as a legal matter, as a practical matter, you do own it. If you have an ownership interest, just in common parlance. So this statutory language, it's not the best drafted legislation I've ever come across. And in particular, it says that the generation facilities or other resources shall be owned and recovered on a cost of service basis. Do you see why that's grammatically problematic? You don't recover facilities. You recover the cost of the facilities. You with me?
I agree that you recover costs, yes.
Yeah, so there's at a minimum, it's not well drafted. I would say there are words implied that are missing that to get a plain meaning would have been incorporated, because as it reads, it doesn't grammatically make sense. And so you have to imply into the language what I just said. And the cost shall be recovered on a cost, utilities cost shall be recovered on a cost of service basis. So if we're looking at having to write words into the statute in order to give it grammatical rationality, you could just as easily write in the words, and the utilities portion of those costs shall be recovered on a cost of service basis.
I don't know if I'm exactly following what the question there is. I would take the position that adding the words you just said is more of a stretch than is appropriate for the words on the page, for what it says. And our view would be the generating facility shall be recovered on a cost of service basis. I would say we all know exactly what that means, and you don't need, there was not a need to put that new word in it. And I'm gonna be the last person to criticize the General Assembly for their drafting skills. I think they do a great job, and I honestly am amazed at how great their drafting skills are.
So Avangrid suggested a scenario in which their equity contribution would be recovered on a cost of service basis. I could ask you first, do you think that that is practical, legal, feasible? And if so, does it remove your argument about not satisfying this statutory language?
I don't think it's practical. I don't think it's legal. And I haven't heard Avangrid explain in any meaningful detail that they're actually willing to submit to what true cost of service recovery is in reality, which is a lot of data requests from public staff, assessment of every single thing you do, subject to discovery on every decision you make, discovery on your board of directors, presentations, like that's cost of service rate making. It works in North Carolina very well. I haven't heard any indication that that's what they're looking for and willing to. And even if that is, I don't believe that's actually what's being contemplated here, but I haven't even heard them say they're willing to be subject to that.
Yeah. Now, also sticking with the statutory language and turning to the issue about the Roxborough facility, the way the wording reads is any new generation facilities, I'll leave out other resources for a minute, any new generation facilities selected by the commission in order to achieve the authorized reduction goals shall be owned and recovered, et cetera. So the Roxborough plant is a facility selected by the commission to achieve the authorized reduction goals. You use the word resources a number of times, but the fact is it is a facility selected under the carbon plan. And the fact that someone else may participate in the ownership doesn't change the fact that that facility, it's just one facility, was selected under the carbon plan. And so I am not sure how you reconcile that with the requirement of with your argument that 100% utility ownership is required.
Again, I don't believe that the commission would take the position that NCEMC's generation is directly subject to your authority under the carbon plan. So I don't see how you could have selected their portion of that plan for purposes of the carbon.
Well, I agree with your first point, my point is simply, I'm not sure how you just read into the statute some ability to talk about portions of a facility. It doesn't say the portion of the facility, of a facility, it says a facility. The facility was selected under the carbon plan. It's just one facility.
Yeah, yeah, that's not how we read it, but I understand the point. I'll also, well, one other, well, no, I'll let that point go.
So, leaving the legal parsing aside for a minute, can you just talk a little bit about, again, leaving the legal issue aside from Duke's standpoint, what is your sort of practical motivation in seeking or wishing to own 100% of these facilities?
First and foremost, our perspective is it's our obligation, your obligation to affect the law as it's been given to us. So that's point one, and will always be point one in our view of this issue. And as I said before, I think there are very compelling policy considerations why direct utility ownership and cost of service rate making provides benefit from the state, especially when you view it in the context of two things. First of all, HB 951 was a heavily contested piece of legislation, but ultimately, like all legislation, was a series of compromises. And that compromise achieved unique bipartisan support. And so it's in that context that it's important, number one. Number two, if you think about the transition we're undergoing as a system, we are moving forward with retirement of aging coal facilities. So part of this transition is a lot of Duke investments that have been made being taken off the table. So I think there's just a little sort of fundamental logic that says, if you want a healthy, strong utility in your state, and you're affecting this transition and you're forcing them to retire 8,400 megawatts of coal, well, let's make sure they still have a really significant ownership share going forward of the resources that come behind to replace those resources. So you have the policy benefits of utility ownership, the policy benefits of cost of service rate making, and the transparency and openness of all those processes. You have the bargain of what all legislation is and our obligation to implement the law as drafted. And you have kind of the natural nexus between retiring a bunch of coal and replacing it. And you want your utility to still be in control of its system with you regulating the utility and providing reliability for customers.
Thank you. Nothing further.
Mr. Druck, I think that's the end of the questions from the commission, and thank you for your argument and presentation. And I think we have 4 minutes for Avangrid to provide rebuttal.
Good afternoon again, Ben Smith on behalf of Avangrid on rebuttal. So I want to address these things very quickly. One thing that we want to discuss is the distinction that Duke Energy is trying to show between the Roxborough facility and what we contemplate in some sort of joint venture. Duke is saying these are two different things. It's a split offtake, and it's a different thing. It's not included in their utilities commission, but are in their carbon plan. However, that's not what they said at the time. In the statement of need, Exhibit 1B, in E2 sub 1318, the Exhibit 1B to the statement of needs stated the proposed facility is part of the least cost path to achieve compliance with the authorized carbon emissions reduction goals in NCGS 62110.9. It further stated the analysis presented within this exhibit identifies DEP statement of need for the wholly owned proposed facility aligned with the CPRP modeling unless otherwise noted. Joint ownership with the NCEMC is neutral to the planning need of the company. In addition, in the rebuttal testimony of James Wilkins on behalf of NCEMC, when asked about dispatch priority, he testified, while the final executed agreements do not yet exist, the parties currently agree that DEP will be solely responsible for for the scheduling and dispatch of output from the proposed facility in accordance with prudent utility practices and without regard to NCEMC's ownership interest. The parties currently agree that DEP will solely determine any must-run dispatch priority. They are trying to make a distinction where none exists. Duke still has dispatch priority with us. Yes, there's capacity that's reserved for NCEMC and that, but this is still a split joint ownership. There's no need to go further. We don't need to talk about whether NCEMC is regulated by the commission in the same way as Duke. I concede that, but I won't concede that Roxborough is some sort of distinct facility outside of what we talked about. And then any bid submitted by Avangrid or any wind developer that does not give 100% is to Duke illegal. That's what they've stated repeatedly. They now say they'll model these non-conforming bids, but then they should be non-conforming. They can't have it both ways. You can't say, we'll take it in, we'll continue review it, but it's also illegal. This is an issue for right now because we're preparing these RFP bid proposals that are, as I've said a number of times, arduous, lengthy, pages and pages of work. And it is important to move forward as efficiently as possible so that we can meet the CPRP, so that we're not litigating this in October. So this is the issue that is before us today. It's ripe. It's time for a controversy to be decided. Thank you.
Thank you, Mr. Smith. We don't have any questions for you, so I appreciate your presentation, and I appreciate the oral arguments from all of the attorneys. They were excellent and very informative. We are not going to be asking for proposed orders from the commission. So we are not going to be asking the attorneys to submit proposed orders, so that will not be necessary unless there's any concern or objection to our proceeding without proposed orders.
No concern on our end other than
Okay.
the timing issue that we brought up.
Okay. Any concern from Total?
No concern from Total.
From any of the other parties? Okay. And
No
from Duke?
No, no objection from Duke Energy.
Okay, we'll have the record reflect that there's no objection. So with that, thank you for your presentations, and we will be adjourned.
Thank you.